I have a lot of question, madam. This application for this, not application, not mentioned by the receiver for his discharge. Your lordship's direction was to matter appear today, but matter did not appear as today. You will give the slip. No, no, it is the second time mentioned. Let the matter appear tomorrow or day after. No. Then I have already issued notice. Reminder din. Item number 51 of my loss. 31, yes. I don't have pass. 31? 38. 38? Yes. Yes. Anyway, if both parties are present at 2 p.m., I can take it up. As my notes. If time permits, if both parties are present, I can take it up at 2 p.m. Should we come at 2? Come at 2. Bring your other side also at 2. Yeah. Yes. 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 In connection with the DNA matter. Yes. I am representing the respondent number 2.3 in that. Yes. So I am told to the department that the file of was managed. So you have filed any application? I am mentioning before your lot. So you file a formal application, that would be better. No. Maybe, but now the matter is disposed. Matter is not disposed anyway. You make an application so that necessary orders can be passed on that. South, the other side. Yes. If there are South advocates. Yes.
Any other mentioning? To be mentioned, item number 1.
Number 1, my lord, I am appearing on behalf of the legal heirs of defendant number 2. I have mentioned the matter before your lordship on 12th June. The opposition was expired, the date of opposition for filing opposition expired on 13th of June. So that's why I mentioned.
So opposition is ready?
Opposition is not ready. So I am praying for the extension of filing the opposition. It's an old shoot and various connected people.
You are appearing for?
For the petitioners, madam.
Are not
For the petitioner, the legal heirs of the plaintiff number 3.
I am for the legal heirs of the defendant number 2, Shoilendra Kumar Das.
Yes.
I'm praying for the extension.
And my lord, in the meantime, as per your leave granted by the earlier order, my lord, I have corrected some names of the legal heirs of the defendant number 1 and 2.
Right.
Let further leave be granted to further service because the new address have asserted.
Yes, ma'am.
Page 8.
Learned advocates for the petitioners.
Corrected copy has to be
Learned advocate for the petitioners, defendant number?
Defendant number 2.
Defendant number 2.
The legal heirs of the defendant number 2.
That means 2A and 2B.
Shoilendra Kumar Das.
Okay.
Connections with the applications.
So you are not yet brought on the record?
Yes.
Learned advocate for the legal heirs of the defendant number 2 prays for time to file the affidavit in opposition.
For extension of
Prays for time. Prays for extension of time to submit the affidavit in opposition. Such prayer is allowed. Let affidavit in opposition be filed by 26th of June.
As per the lordship order, it was a returnability. Terms of the order dated 21st May, the returnable date on 26th.
Okay, then you file it by 23rd June. Can you file it by 23rd June?
3 weeks time more.
Okay, I'm counting you 26th June. Reply, if any, by 36/2000 25. Let this matter appear on 2nd of July 2025. Let it appear on 2nd of July.
Corrected copy has to be served upon us.
Yes, let the corrected copy of the plaint be served upon the parties.
And also give liberty to further service upon the defendant number 2, that is 1, that is Indra Kumar Das, legal heirs upon the, because new
Legal
address
heirs
have
are not
asserted.
yet, legal heirs are not yet substituted.
That was served, my
substituted.
lord, substituted.
Okay, okay.
New address have asserted.
Yes, yes, yes. Liberty is granted to cause service upon the legal heirs of the deceased defendant,
One,
defendant number 1,
One.
and this is defendant number.
2 already
Two.
appeared. 2 already appeared.
Okay,
She
this
have
is defendant number 1.
Why not in regard to the correction of the hostile deal, the name of the defendant number 2 is wrongly implicated. Should be Shoilendra Kumar Das. It's not Shoilendra Nath.
That has to be deleted now. I think defendant number 2 has to be deleted. The heirs are to be brought on the record.
Yes, we agree to it has to be brought.
Defendant has to be deleted and heirs are to be brought on the record.
Item number 2 with item number 3.
In this matter, your lordship, I
Item
am
two.
appearing for the, yes, my lord. I am for the respondent, the caveator in the testamentary suit. My lord, my witness is present, but unfortunately, instead of your lordship's direction, since the matter was to be appeared as an evidence.
No problem,
witness
my lord.
action, when it-
Nomenclature
witness
is
action,
not a problem.
Just come as to be mentioned.
Well, no problem.
Kindly, please. Kindly fix the matter today at 12. I think my learned
I have no objection.
friend will consent.
I have no objection.
That interpreter has to come, my lord.
Or I can do one thing, I can keep it tomorrow also.
My lord, since he has come from outside.
He is a resident of
My
Calcutta.
lord, the witness is an aged
He is a resident of Calcutta.
No.
No. He is coming from the other state, from a distance, my lord. And
Okay.
that is why it was adjourned on the last occasion.
Not the last occasion.
So let it be taken up at 12:30.
12:30. Okay.
12:30.
Yes.
Yes.
Interpreter may be called, my lord.
Interpreter के बोले देंगे 12:30.
Interpreter. And people.
Item number 4.
Well, I do not know why this matter has come up as to be
So
mentioned.
what is the present stage?
Present state is a witness action.
Witness action.
Witness
You are for?
I am for the
Petitioner.
plaintiff.
Yes.
Now, my lord, we have discovered, my lord, it's a change brief. It's come to us, my lord. We have now, my lord, gone through the plaint. My lord, what has happened is, my lord, there is a
Change.
মানে আমার কাছে
Okay, yesterday it was mentioned.
Yes, it was mentioned. I have given
Without
notice to my
knowledge,
What
learned.
is to be done?
I have given notice to you, sir, the moment it was allowed.
It was mentioned in my absence.
No.
Hey.
Prior to mentioning, notice was served upon you.
No.
My lord, no
But
notice was
yesterday-
served. I had
Yesterday, no notice was served.
Anyway, after mentioning, notice was served.
problem is, my lord, nobody allows the other person to speak. My lord,
this is a fact.
my lord,
I
the
am
matter
just
was a-
stating the fact.
Please allow me to submit.
Yes,
sir.
now what is to be done?
My lord, what happened was the matter was in the list. We mentioned that we will possibly be asking for, my lord, transfer of the suit to the commercial side.
Have you
Be-
filed a petition?
No, my lord, allow me, my lord. So your lordship heard it. You said lordships, and I said that I have not given notice, my lord. I am mentioning without notice. Kindly, my lord, let it appear tomorrow. I will give notice. I have given notice thereafter. He is here. I have not stolen any march over him. Number one. Number two, my lord. The suit has been filed in 2014. Thereafter, the Commercial Court Act has come in. My lord, there was some confusion all this while regarding, my lord, that, my lord, judgment where, my lord, it says 106 of Transfer of Property Act. If there is a notice, it is not commercial suit. That's why we did not mention it all
The
this while.
question is that matter decided by the division bench?
Now, my lord, that is not decided. But, my lord, we have taken a legal we have, my lord, consulted amongst ourselves. It has come.
Are you objecting to his application to transfer this matter
He
to
has not filed any application.
There is no application that is required. My
Better
lord,
file an
my lord, there
application.
is no application that is required. Kindly see the
But
plaint.
the question
You want a transfer, okay, on the ground that this court does not have jurisdiction, okay.
Yes, my lord.
Now on you.
I am the plaintiff. I am saying it is not that the defendant is saying this court does not have jurisdiction.
File an application, let me hear both of you.
My lord,
and thereafter,
my lord,
let me take a decision.
kindly appreciate one thing. What will an application do? In this matter, the only thing that your lordship has to see is the plaint. But it's the plaintiff who is saying transfer. It's not that the defendant is making an application for return of the plaint or anything of that sort.
Earlier, they opposed that this is not a commercial matter.
So that is what I began with saying, that we have reconsidered our position in law.
Better you file an application.
Lord, kindly see the plaint. There is no application is required. Kindly see the plaint. Either your lordship decides to keep it this side or your lordship sends it. But what will I say in the application? Lord, all I'm saying is that the plaint is based.
If you file an application, your other side can get ready. Whether
Lord,
to consent or to
my lord, that my learned friend will come, and I'm not saying transfer it today. Let my learned friend get ready. But all I'm saying is kindly look at the plaint. The plaint is on the basis of a contract which is commercial in nature. I have given State Bank on rent.
Now in that, with regard to that, you see, the matter was pending before the division bench. So I am asking you.
No, my lord, that's what I'm saying. Kindly allow me to place. My lord, the division bench matter is what? The division bench matter is saying that if a lease is terminated by way of 106 notice.
Right.
Kindly bear with me. With 106 notice.
Contract for what?
Kindly let us go one by one. It is the division bench matter says if it is 106 notice termination, then it is a right flowing from the statute, that is Transfer of Property Act. Hence, my lord, it will not come under the Commercial Courts Act.
Okay, come on Monday, let it appear.
Yes, here is a matter. Just let me make my submissions clear. Here is a matter where there is no 106 notice. The lease has expired by efflux of time, and thereafter we had asked State Bank. State Bank wanted 2 more months to vacate the property. Now we said very well, if you want to vacate by 2 months, you have to pay an enhanced rate of rent. Whether that rent is payable by them or not is the question that is there in this suit.
And also
Now,
security deposit.
Yes. So that is the dispute.
With them.
So if that is the dispute, that is a purely commercial dispute.
Because you see,
Because
I
ultimately,
am asking you because if you file an application, whoever is aggrieved by a decision on the application may go before the division bench. Suppose both of you place your case, okay? The court may accept your contention, court may not accept your contention. So, if you are aggrieved, you can take that in appeal also.
But even if your lordship, my lord, first of all, it is barred under 13. One cannot go. Second of all, my lord, even if your lordship passes a decision after hearing both of us, we can always challenge it. There is no application that is required. But this I will disabuse
Section 15 of Commercial Code.
Yes, section 15 does not
When can you come ready with regard to the maintainability?
Yes, come ready. I am not saying here.
If they file application, I will.
Why application? I am not understanding.
Why they are side to feel filing?
What purpose?
Earlier they opposed this point.
They agreed.
So basically, I'll have to. Basically,
Since
the point is that they will now go up in after the entire matter is heard out in appeal. They will go and say, "Look, the court did not have jurisdiction."
Let him say here and now. If
Let him. I am not saying today. Let him say on Monday. Let him come ready. I'm not pressing for hearing today. I am saying the application will not serve any purpose.
Is clear. Either party can file application. If
Please let him show that the application is required.
Only consider.
He wants to make the argument. Let him make the argument.
Subsection 5. If suit has not been transferred, then any party can make application for transferring.
Yes.
15.5, subsection 5.
But first, my lord will read subclause 1. All suits and applications, including applications under the Arbitration and Conciliation Act relating to a commercial dispute of a specified value pending in a high court where a commercial division has been constituted, shall be transferred to the commercial division. This is suo motu.
Those matter has not transferred.
Will be transferred.
It has to file.
No.
The thing is, it has to be decided whether it is a commercial dispute.
Absolutely. So, what will you look at for that? Only the plaint. What will you look at? What will an application serve? Only
Okay,
thing that
when
you
can
look
you
at
come
is,
ready?
yeah, let him
Just
come
tell
ready.
me.
I'm not
You
trying-
argue whether it is to be transferred or whether the
Yes.
court has to return the matter.
If they file any application, I will deal all these things.
Understand
What is harm of filing any application?
what will you achieve by filing an application?
Section 2C.
So the application will be under section 15(1).
My lord, 15(1) is a
15(1) will
secondary
be-
provision. I showed you one which says shall be
15(1)
transferred.
Yes, yes, 15(1).
15(1) shall be transferred. Suomo 2. My lord, we are doing it every day in other courts. My learned
Read
friend,
with
learned friend.
subsection 5. If the suit has not stand transferred, then party can file application.
Let him record,
In
then let it be recorded. Let it be recorded then
That
that he does not want it to be transferred to the commercial division. He's opposing. He's saying it's a
And you're-
non-commercial suit. Let him say that. আরে জজ সাহেব তো বলছেন আমি তো প্লেনটা দেখাবো। It is to be decided on the plane whether it's a commercial suit or not. Let him come ready. I am not saying insisting
No,
him
if
hearing
you-
today.
I will.
Now
do
the
my-
question is, okay, if you want a transfer, you come with an application.
Yes,
If you want the suit to be transferred,
I do not want to transfer.
He doesn't want to be transferred. So he says it's a non-commercial suit. Your lordship will decide. Look at the plane. Kindly allow me to place the plane.
okay, please come ready. I shall take up
Yes.
the matter. Learned advocate for the
Fine.
plaintiff and learned advocate for the defendant are present. Point is raised with regard to the jurisdiction of this court in adjudicating this suit
তাহলে কতদিন চালাবে?
on the ground that this suit involves adjudication of commercial dispute and it is to be transferred under section 15 within bracket 1 of the Commercial Courts Act 2015. Thus,
কেন পাবো?
this matter stands adjourned
আমার তো চেম্বার আছে।
till
হোয়াটসঅ্যাপ দিয়ে দাও না স্যার।
2nd of July 2025 for the parties to for the parties to submit written notes of arguments and
Very
and
good.
submit the matter.
Very
Yes, come with your written notes of argument. 2nd of July.
But instead of 2nd July, can it be any other? 1st or 3rd, whatever. I may not be in the High Court. Or someday in June, my lord. We were wanting to expedite the matter, my lord.
Okay, 3rd July.
3rd July. But 2nd, 3rd, both are not in town, my lord. If your lordship-
Fourth is a Friday. Then there is actually
But
on Friday,
someday in
time is
June,
very limited.
someday in June, last day of
Under
June or
7th July,
something. Someday in June, my lord. How
because
long
I
will
have
it
to
take?
communicate this to bank.
Okay, let it be 1st of July.
1st of July. 1st.
For orders, item number 5.
This is the matter where both the parties had filed their
Yes,
written
today is
notes
the
of
date fixed for
submission.
passing orders.
Yes, your lordship.
No argument. Yes, I'm reading out the operative portion only.
Yes, your lordship.
Yes. This petition is allowed. This petition should be allowed. Let there be an order in terms of prayer A and B of the master summons dated 19th day of May 2025.
Grateful to your lordship.
Item number 6.
Huh? Allowed, allowed.
Probably a cherry ticket.
Allowed and disposed.
I appear for the plaintiffs, my lord.
Yes, item 6.
Appear for the
Was there
defendant,
any
your
date fixed for passing order on GA?
No, lordship, there is no pending GA, my lord.
So, no.
In terms of my lord's last order, the
No.
department is supposed to file a report with regard to impounding of a
Assessment
document.
of stamp duty, your lordship. The
Yes.
collector was.
That
Yes.
order is already passed
Yes,
earlier.
yes, order has already been passed. We have
Please speak
already
for the report.
report and the defendants have also granted liberty to file their affidavit of documents.
Let me see the last order.
Yes.
রিপোর্ট এসছে এখানে রিপোর্ট বাই দ্য রেজিস্ট্রার date is fixed for submission of the report.
So we have communicated this order before the learned register via a letter dated 19th of May.
Record an order. In terms of order dated 5th May 2025, where an order was passed directing the registrar original site to send the matter to the collectorate for assessment of the stamp duty and for submission of the report. No report is filed to date. Let this matter appear on 30/6/2025 for submission of the report by the registrar. Let a copy of this order be sent to the registrar.
New motions, item number 7.
7, my lord, this is my application, that is GA 16 of 2024. Well, this is coming up after affidavits. It's a short application, my lord, though there are several pleadings here. Our case is very simple. The suit is for partition.
Here 16 is for what? You are for?
I am seeking addition of party. I am the intervening party.
Oh,
I
you are
want
the
to
applicant intervener.
applicant intervener. I want to implead in the suit. That is all.
Here I am opposing.
Yes.
You have filed your affidavits.
It's already filed. The affidavits filed, thereafter supplementary affidavit, then a response to the supplementary affidavit as well.
Sir, I'm not going into any of
Sir.
my affidavits.
My only case in my application is, my lord, perhaps all the pleadings were not necessary in this application. Our short case is one of the scheduled properties in a suit for partition belong to me. This is my short case. I've stated that on oath. I have a certified deed in that regard. I'm seeking impleadment in a suit because my rights will be affected in case any decree or order is passed in this suit. Your lordship knows that under Order 1, Rule 10, a necessary or proper party is any party whose presence is required for adjudication
So
of the
you are,
suit.
according to you, you own
The
some
owner.
of the portion of the
Yes,
suit
yes,
property.
Yes. My lord, there were my predecessor in interest, who has passed away now, had purchased a portion of the suit property. He filed a prior application that was GA 14 of 2024. That application unfortunately was dismissed for dismissed. That is not for default. It was dismissed. It was
Just on merits.
not on merits. I will show the order. It was dismissed for default, not on merits. And that too at a time when my predecessor in interest had already passed away. My predecessor in interest had passed away. I am the executor of the will left behind by my predecessor in interest, who was also an applicant seeking to intervene in the application, in the suit.
Sir, may I
That
just
is my
stick
short
to one maintainability point, and then my learned friend can argue
Yes.
in 1 minute. Milord, my learned friend contends, Milord, he is the alienee of a property in a suit for partition. We say, Milord, he is not the alienee because the actual, Milord, transferee, their defendants are, Milord, defendant number 16A to 220. He's an imposter. Now, Milord, imposter files an application for addition of party. That application is dismissed for non-appearance in my presence. My learned friend claims, Milord, that he is, Milord, a legatee of that Milord, that imposter. So his predecessor applied, the application was dismissed for default in my presence. Order 9, Rule 9 prevents him from either him or any of his the imposter or any of his successors from coming again. This is short matter. Order 9, Rule 9 bars him from coming. Apart from that, the facts are there.
Was that application dismissed?
21st of November 2024. I'll read, Our presence is noted. All my learned friends appeared. Then plaintiff, none appears on behalf of the applicant. Plaintiff respondent is represented by order dated 3rd February 2023. Leave was granted to the applicant to file supplementary affidavit disclosing documents. Neither applicant is represented nor any supplementary affidavit in compliance has been filed. In the aforesaid backdrop, application being GA number 14 of 2022 stand dismissed for default. Now, Order 9, Rule 9 of the Civil Procedure Code, it's very clear where a suit, is wholly or partly dismissed under Rule 8, plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action, but he may apply for an order to set the dismissal aside, and if he satisfies the court, the sufficient cause for non-appearance, it can be done. Now, this is not, Rule 8 says procedure where only defendant appears. Now, this will also apply, to applications under section 141 of the code. So this stares at my learned friend clearly on his face. He can't, I've got the cases also. It's not possible. He has to, apply for recall of that order. If he has that order recalled, then he
The earlier application was filed by whom?
his
By my
predecessor.
Predecessor means
I am the executor of the estate of the person who had filed that application.
Right.
I am my successor. Yes, yes.
Now, second, he claims as a
so what is the difficulty to get that restored?
he has
May I
to,
indicate? I need not. I need not. I'm sorry, my lord, but I need not. I'll indicate why. Page 18, if my lord kindly comes to, of my application. My predecessor, who was the applicant in GA 14, had passed away on the date the order was passed. That order is a nullity in the eye of law. It's a nullity which need not even be recalled. My lord, I'm not carrying those judgments today, but we'll produce the judgment before your lordship. At an order passed against a dead person is a nullity in law. This is an order passed against a dead
This is
person.
27/1/2024.
Yes. And that order is November 24.
On which date?
November
Set date.
21st,
so he had
November
to,
24.
substitute himself in that application.
Your lordship, if that application were alive, the question of substitution would come. But as on date, the order that my learned senior friend seeks to rely upon is a nullity in the eye of law.
No,
And
no,
that
no.
is
This order was passed prior to death or after death?
after death.
After death.
It's an order passed against a dead person. It's a nullity in the eye of law. I'll carry those judgments. I'll
No,
place
you
that
had to,
before
you
your
had to
lordship.
appear, you had to, under Rule 10A,
Your lordship might-
No.
might-
Suppose in a suit is dismissed, okay, when the sole plaintiff died, okay. After that, the suit is dismissed for default. Now the question is, the plaintiff's legal heirs are to get that suit restored.
yes.
Your lordship, that is first and
Same
foremost my
case,
preliminary.
plaintiff dies, and
Correct.
after that,
Correct.
it was not brought to the notice of the court, and after a few days, the suit is dismissed for
Your
default.
lordship, in that case, first and foremost, my submission is this is not a suit, this is an application or intervention. Stricto sensu, Order 9, Rule 9 will not apply in this case. Number one, even though Section 141 makes the provisions of the orders applicable insofar as applicable. But in this case, Your Honor will kindly, Your Lordship will kindly bear in mind that here, this is an order of dismissal, which was unbeknownst to me. I am the executor. My pleaded case in my application is I came to know subsequently. And if an order is passed, today my right, Your Lordship will kindly appreciate, my right and cause of action in the application is to intervene in the suit. No right of my client, no substantive right is decided by this application. It is only for impleadment in the suit. That is all. It is a procedural application. If a prior procedural application which was filed by my predecessor, who had passed away as on that date, was dismissed for default, that order will not bar my client from coming to court saying that I'm the executor of this person who was the owner. Your Lordship, today, the application, let us assume that that application did not exist. Would I not have a right to come to court? I would still have a right. I am deriving my title from a person who claims to be the owner of the property.
Whether you can have any better right than them.
I cannot.
I
That is the
cannot.
question.
But a right to apply for impleadment is not a substantive right. It is merely a procedural order I am seeking for
Because
impleadment.
it is not an independent because you are deriving that right from.
Yes, yes, that right still survives. My substantive right is not decided by that
Now, this is
order.
a purely question of law. Come with your written notes of arguments on the
And
decisions.
judgment, I have judgments
Lordship,
today
sir.
also, I
come,
can,
come with a compilation
I will
written
do that.
notes.
Your Lordship.
Yes, when shall I keep it for filing the written notes?
Lord, whenever your lordship wants, Lord, my learned friend can decide.
Whichever date, Your Lordship. We don't stand in the way. Give us a week.
And with
Your
regard to
Lordship,
facts, affidavits are there.
affidavits are
Yes.
complete, but need not be gone into in my humble
The
submission.
second point, my lord, which I did not indicate is, he, my lord, is claiming to be beneficiary under an unprobated will. He has no locus.
That
That will also
again,
be decided.
your
We
affidavit,
will-
it is there, learned advocates for the parties are present, hard learned advocates. Let this matter appear on
The 2 weeks time I'm being instructed to seek, my lord. 2 weeks hereafter.
2 weeks' time.
If it commences to, my lord.
Okay. 7/7/2025 for orders, written arguments shall be filed on or before 1st of July.
My lord,
Yes, yes.
since my lord is directing us to file our written notes, could the submissions made by the parties be recorded so that later on further?
We will put it in the note.
Because I am not getting an opportunity to place my application separately. Preliminary objection is being decided.
It's a
by my lord.
question of law regarding whether you
It's
can
really
file
on
that.
maintainability.
On
The
maintenance.
factual aspects are already in your affidavits. Entire things are on record.
Yes.
So I am granting you opportunity to file your written notes of arguments
My lord.
on or before 1st July. Okay. And the matter shall appear on 7/7/2025 for orders.
Obliged.
Let my learned friend need not be apprehensive. I will give him a copy of my note.
Yes, we will also exchange. We'll also.
So that he can come well prepared.
Obliged.
Okay. So I think sufficient time you are getting.
Yes. No hide and seek in court. Grateful.
Obliged.
আর কোনো আপত্তি নেই?
কাজ করুন এটাকে কালকে টু বি মেনশনে দিয়ে দিন। পার্টিদের জানিয়ে দিন যে কালকে থাকবে টু বি মেনশনে। হ্যাঁ, ওটাকে তাহলে জাস্ট নট টুডে হয়ে যাচ্ছে, নট টুডে হয়ে কালকে থাকবে। কালকে কালকে টু বি মেনশনে থাকবে আর কি। রেজিস্টার দেখুন। ঠিক আছে, ওটাকে নট টুডে করে দিন আর ইন্টিমেট করে দেবেন আর কি, কালকে টু বি মেনশন।
Item number 8.
8, Lordship, I am appearing for the plaintiff.
It's a restoration application.
Restoration application along with. He has already received a copy in terms of your Lordship's order.
But only two things subject to my hotline. But in essence, says
For GA5 and GA6.
GA5 is for lordship consideration of delay of 500 days, and 6 is for restoration. But subject to my hotline, and it's can says malada. I don't want to lordship stand in the way, but there's a delay of 500 days. That can compensate to that.
Was
My
that
client is in deathbed. My client is in deathbed. She has to required to come before this court for proceeding of this case.
But kindly compensate to that effect, because there's a delay of 500 days. I don't want to also stand in the way of the restoration of the suit.
No, but here also he has justified due the illness of his client.
Several
But I
type of
don't understand for any opposition to this application. But I may have been paid first in first instance, when you allow me to file an opposition, and the opposition replied, it will take a
already
much
he
time.
has both of them, not only plaintiff and her husband, both of them were in trouble regarding this illness and
delay of
still
500 days, my lord. Well, kindly
all of
consider
them
the
were
technical-
in
500 days.
so many times they were admitted in nursing homes.
আচ্ছা ইয়েটা এই দুটো নোটিশ অফ মোশনটা কোথায়?
I'm not praying if your lordship to allow me to opposition, or my lord, it will take time.
ওটা GA5 এ তো নোটিশ অফ মোশন নেই। In GA5 there is no notice of motion.
So, notice of motion is there for two applications, 5 and 6.
No.
That is the notice of motion
Both.
is required for the one.
Okay, no. You have which application?
This section, the condonation of delay and restoration, both of them can be filed in a one notice of motion.
Thank you, sir.
5, section 5, condonation of delay, restoration,
Next item, right.
8 and 9.
Notice of motion was served with regard to GA6.
GA6 and losses the section 5 is also there
So
in the separate
GA5,
application.
GA5 is your restoration and GA6 is the condonation of delay.
No,
Condonation
5 is
Condonation of
condonation of delay.
GA5.
5.
Total 500 days.
Yes, loss. Now your lossy will decide. My learned friend has said.
Yes, record an order. Learned advocate for the petitioner plaintiff and learned advocate for the defendant opposite party are present. The application for condonation of delay and the application for restoration are taken up for consideration. Our learned advocates peruse the petition file and materials on record. The petitioner has enclosed annexed medical documents showing the illness suffered by the petitioner as well as by her husband. It is further contended that due to communication gap with the learned advocate, the petitioner plaintiff did not have knowledge of the dismissal. Is it the same advocate who was
No, previously who was appearing, he also died.
learned advocate?
Yes.
So prior to this
That initially Mr. Sopon Monlik, he conducted this case. Thereafter it
he
has
died
been-
prior to dismissal.
Yes. He died
Yes.
at dismissal. Second
Right.
advocate came into the lordship.
Okay.
My
It is
learned
also
advocate
submitted by learned advocate that the former advocate died. That is why no further step.
No, this is not the fact. the earlier learned advocate died prior to dismissal. Thereafter, new advocate came into the lordship. New advocate.
At the time of dismissal, another advocate was engaged.
Yes.
After dismissal of Mr. Swapun Malik, I appeared.
No. After death of the former advocate, was new advocate engaged.
Yes, I appeared.
So prior to the dismissal, you are engaged prior to dismissal.
Yes, dismissal was in 2023, Lordship.
Yes, although the petitioners have furnished grounds for condonation of delay, and the ground for being absent on the date fixed. However, this court is of the view that this application should be allowed upon payment of some costs. Thus, this application GA6 of GA5 of 2025 and GA6 of 2025 stands allowed. Let there be an order in terms of motion dated 11th day of June 2025. Let there be an order in terms of prayer A. In terms of prayer A, in terms of the notice of motion dated 11th day of June 2025, subject to the payment of costs of 60 GMs by the petitioner plaintiff to the opposite party defendant. Restored. Yes, let the cost be paid within 2 weeks. Okay.
Yes. And this will be appear in the
Good stands restored.
This is restored and this will be appear in the next.
Yes. You mentioned after paying the costs. You mentioned
after formality.
রিপোর্টটা ছাপানো হয়নি। ঠিক আছে, 10 নম্বরটা কল করে দিন, 5 ওভার করে 12টার সময়।
Item number 10.
Your Lordship will be pleased to recall, this is a matter in which, my Lord, the petitioner is seeking for a recalling of an order passed by my Lord, wherein, my Lord, the parties had agreed to withdraw the suit. My Lord, my client's case is that my client is one of the plaintiff number 10 in a partnership firm. The other plaintiffs, my Lord, behind the back of my client, in spite of my client having had informed that he does not want to withdraw the suit, my Lord, represents.
The affidavits are exchanged also.
Yes, my Lord, the affidavits are exchanged, and Mr. Rupak Ghosh, my Lord, who is appearing on behalf of the other plaintiffs, I suppose has already made his submission. Mr. Shoma,
It is your petition.
my application.
It is at the time when affidavits were not complete. Now it is
Anyway,
complete.
very well. Yes. My Lord, may I file the affidavit in reply to both the sets? One is that of Mr. Rupak Ghosh's client, that is the other plaintiffs, and, my Lord, the defendants. My Lord, if your Lordship kindly comes to page 42 of my petition. Your Lordship has got that, man. Oh, I'm sorry.
You have filed a supplementary affidavit also.
Yes, my Lord, that is only, my Lord, annexing the partnership deed. Just to reflect as to what were the clauses in the partnership deed. Page 42 of my petition, my Lord. I'll start with the prayers of the plaint that was filed by all the plaintiffs.
Yes, page 42.
Yes, my lord. These are the prayers that all the plaintiffs had filed the suit. Decree for eviction against the defendant numbers 1, 2, and 3 from go down numbers 7D and 7E at 10 Portuguese Church Lane, Kolkata 1, and harsh possession thereof, particulars whereof are set out in schedule annexed hereto and marked with the letter A. Decree for rupees such and such on account of mean profits against the defendant numbers 1, 2, and 3 as pleaded in paragraph 26. And then, my lord, mean profits. My lord, this property is, my lord, the partnership firm is a tenant with regard to this property. According to the partnership firm and all the partners, these defendants, my lord, were being put there as caretakers. But ultimately, they had been wanting right over that particular property, as a result of which this suit had to be instituted. And your lordship will be pleased to appreciate that all the partners instituted the suit at that point of time. Now, my lord, your lordship will kindly come to page 61. What, in short, is the case of the defendant? I'm just bringing all this to your lordship's notice to show the importance of the suit.
Yes.
And withdrawal of which will be so prejudicial to the partnership firm. My lord, only one paragraph, page 61, that is a continuation of paragraph, my lord, tell your lordship, that's a continuation, I suppose, of paragraph 4. My lord, A, small a, your lordship will find that, my lord. The plaintiff firm would surrender tenancy to Waqf estate in order to facilitate the grant of tenancy directly by the Waqf estate in favor of the defendants. So this, in short, is the defendant's case, that now, my lord, the tenancy has been given directly to the defendant. Our case is that we have tenants, we had put them as caretakers, but their case is that they have become direct tenants from the Waqf estate. So this is what we are trying to oppose.
Plaintiff's case was the defendants are the caretakers.
Exactly, man, or the go downs.
Right.
Of which the plaintiff partnership firm is the tenant. And the defendant, who are the caretakers according to us, are claiming their right on the basis of this. In short. So, my lord, we had filed this suit, the partnership firm had filed this suit for the purpose of eviction. Yes, for the purpose of eviction, so that we can get back our possession. So this is the importance of the suit. And my lord, your lordship will also kindly see that this suit was filed, my lord, this suit was filed pursuant to leave given by this honorable court, which would appear at page 40 of the petition. This is a part of the plaint. All the parties are parties to this. Page 40, paragraph 24.
Yes.
By an order dated November 26, 2012, passed in WP number 757 of 2012, this honorable court was pleased to grant leave to the writ petitioners therein, while dismissing the writ petition as withdrawn, and was further pleased to grant liberty to the writ petitioners to seek remedy before the appropriate forum in accordance with law, if so advised. A true copy of the certificate. So it was pursuant to this leave that the plaintiffs had sought this remedy with regard to the file.
Client along with other plaintiffs.
Yes, yes, all the plaintiffs. That is the most important factor, my lord. All the plaintiffs had joined. Now, my lord, I'll tell you, take your lordship to page 94. I'll just indicate the pages. Page 94, my lord. This is an order of this honorable court, my lord. Your lordship will, I'll not trouble your lordship with the entire order. If your lordship kindly comes to the last paragraph, in spite of directions.
Yes.
In spite of directions, no affidavit in opposition was filed by the defendants. No documents are on record to show their entitlement to such possession. There is no dispute that the defendants had entered into the two go-downs as caretakers, but now they claim rights adverse to that of the plaintiffs. Therefore, on the above case, the plaintiff's right of possession is prima facie established. So, my lord, this has been held way back in 2014. So prima facie, the plaintiff's case of that being the tenant and the defendant being a caretaker has been held by this honorable court. I'm just trying to highlight the point, the importance of continuing with the suit and how it would benefit the partnership firm. Thereafter, my lord, the other directions with regard to the receiver and all that, I'm not troubling your lordship for the moment. Then, my lord, your lordship will kindly see the stage of the suit, pages 99 and page 101. And all along, parties had been taking steps. This is also a part of the order dated 14 July 2015. My lord, I'll not trouble your lordship with the entire order. Page 99, if your lordship kindly comes.
This application was for appointment of receiver.
Yes, this application, in which
No,
orders were being.
application which you have annexed
Yes.
was for appointment of receiver.
Yes, yes, yes. Your lordship will kindly come, my lord, to the third paragraph, which starts with considering all these facts. Considering all these facts, I'm not inclined to vacate or modify the order dated 27th of January 2014, which is an interim order. However, since the suit has progressed and is now ready for trial, excuse me, my lord, this order should not be used to dispossess the defendants in case of any default till 30th June 2016, thereby giving a chance to the parties to obtain a final decree from this court. So, my lord, way back in 2015, the suit was ready for trial. The stage of the suit, my lord, at which it is wanted to be withdrawn for reasons best known, my lord, to all of us. Then 101. 16th August 2017, that was 15, this is 2017. It is submitted by the counsel appearing for the parties that the suit is otherwise ready for hearing. Let the suit be included in the list on such and such. So the suit was being taken care of, the suit was proceeding, the suit was ready for hearing way back since 2015. So that is the stage of the suit. Then, my lord, 102. One by one, I'll just indicate. Then 15 September 2017, issues have been framed. Both parties are all throughout present.
15th of September.
Yes, my lord, page 102.
Okay.
Quite a few issues.
Anyway, suit can be settled at any point of time.
Yes,
There is no
it
such
can,
part.
no, it can be. What I'm trying to,
Whether the bona fideness of the parties or
yes, what
whether
I'm
it is
trying,
done in accordance with law.
what, my lord, I'm trying to impress upon your lordship is that the suit and the continuation of the suit and the final decision of the suit is very much essential for the benefit of the partnership firm's business. And the parties all throughout, all the parties all throughout had taken bona fide steps.
So the court has power to refuse leave.
My lord, my humble submission would be, if it can be shown by the applicant herein, that is the plaintiff number 10, that the withdrawal of the suit would not inure to the benefit of the partnership firm, then your lordship would be pleased to recall the order of withdrawal. Firstly, my lord, because I was not a party to that withdrawal, I had intimated the advocate on record who was representing all the plaintiffs that I would not like to get the suit withdrawn.
Your argument is twofold. First of all, the application and the order which was obtained is vitiated by fraud. This is one aspect.
Yes, my lord.
The other is, even if you support them, the withdrawal will not benefit the partnership firm. That is, these are the two contentions.
Yes, my lord. And that I had intimated them. I had intimated them with regard to my not wanting to withdraw the suit. Having had not brought it to the notice of the court, it was construed before this honorable court that all the parties were present. If your lordship will kindly come to pages 245 and 246, I'll take your lordship straight to that. The order that I'm wanting to recall. Volume 2 of my petition. Pages 245 and 246. What was represented before my lord which made your lordship pass this order?
Two 45.
My lord, 245, yes. My lord, this is your lordship's order. It is 2nd May 2025.
Yes.
My lord, your lordship will be pleased to see the appearance. It's very important. Mr. Topon Sheel, advocate, erstwhile advocate and record of the plaintiffs.
Yes.
Then, my lord, I was not represented. My advocate and record was also not represented. Then, my lord, learned court representing the plaintiff, learned advocate representing the plaintiff and the learned advocate representing the defendant are present, which is incorrect. I was representing one of the plaintiff. I had brought it to their notice that I am representing it through a different advocate and record, that I had appointed a different advocate and record.
So representing the plaintiffs. So all the plaintiffs were not represented.
I'm obliged. In spite of the fact
Former advocate was present.
In spite of the fact of their knowing that I'm not wanting to withdraw the suit, in spite of the fact of their knowing that I had appointed a separate advocate and record, because my interest was clashing with that of them, this was not brought to my lord's notice. Mr. Such and Such, former advocate for the plaintiff, is also present. I had intimated that I want to file a wakalatnama and I want a no objection from you, and that I am having a separate set. I will show all those letters, my lord. And all these letters and all this communication has been made prior to the passing of this order. So, my lord, my humble submission is, was it not the duty to bring this fact before this honorable court? Then, my lord, it is submitted by the learned advocate representing the plaintiffs again and the defendants that the parties have settled their dispute and the suit may be disposed of. Terms of settlement is also filed in court. Upon hearing the learned advocate for the parties and considering the terms of settlement, this court is of the view that the prayer for withdrawal of the suit should be allowed. And then your lordship was pleased to direct the receiver, with whom a sum of rupees 21 lakhs was being to give it to the credit of the suit by a particular time. Thereafter, we brought this application, and my lord, your lordship has been pleased to stay the operation of this order. Now, my lord, I'll once again trouble your lordship with some of the documents which I suppose I should, my lord, indicate. My lord, page 203, if your lordship kindly comes.
Yes.
My lord, the dates are very important. Your lordship's order was that of May. My lord, this is of March 2025.
Yes.
Your lordship was pleased to pass that order on the 2nd of May, and this is of March. Your lordship will kindly see. I'm addressing it to the concern who was being the gentleman whose name was appearing in the list was representing this concern. In your lordship's order, your lordship will see 245, 246.
Yes, 203.
Yes, now I'm showing 203. If your lordship kindly sees this along with 245, what I'm trying to draw your lordship's attention.
245, the order. Okay.
Yes, my lord, the appearance, erstwhile.
This letter would have been placed, maybe this order would not have been passed.
I'm obliged. I'm obliged. And this letter was written to someone who was there before this court. Appearance.
This learned advocate and solicitor was representing all the plaintiffs.
At one point of time.
Yes, thereafter, so far your client is concerned, he wanted to withdraw the power.
Yes, from 20th of March, by this letter, which I'll place before my lord, I had withdrawn. And this gentleman at the time of passing of the order was present before my lord, but this fact was not brought to the notice. So that is what I'm trying to impress upon. So, my lord, if I may just indicate. First of all, thank you for informing me over telephone about the letter dated 13th March, sent to your office by one Shom Shankar Mukhopadhyay, claiming himself as a partner of Mrs. Ashutosh Roy, Prafulla Roy. In this context, I would like to inform you by this letter that I am nowhere authorized, I have nowhere authorized the said Somshankar Mukhopadhyay to issue the letter dated 13th March 2025 for withdrawing the above mentioned suit. Specifically, I'm mentioning and expressing my view pending before the Honorable High Court at Calcutta. Not only that, this is also to inform you that as per my knowledge and records, the said Somshankar Mukhopadhyay is no more partner of Mrs. Ashutosh Roy, Prafulla Kumar Roy partnership firm. He has already assigned all his right as a partner to Mrs. Shonali Roy and another partner such and such. Therefore, as a lawful existing partner of Mrs. Ashutosh Roy, Prafulla Roy partnership firm, my humble request before you not to take any action for withdrawing the above mentioned suit on the basis of the letter dated 13th March 2025. Furthermore, kindly issue no objection wakalatnama in my favor in the above mentioned suit. So, my lord, I had requested for the no objection. That your lordship will kindly find. Then, my lord, 206. Yes. My lord, I'll not trouble your lordship with the entire order again.
Anyway, this is the reply.
This is the reply, your lordship. This has been given to everyone. Page 207, your lordship will see. Somshankar Mukhopadhyay, who is claiming to be the power of attorney holder. 8, he has also been given. All copies. My lord, your lordship will kindly see the last line is very important. This is again also much before the passing of this order. The last line. The said Sujoy Mukherjee, that is my client, also asked us to issue no
205.
206, my lord.
206, yes.
Last line, my lord. This Chatterjee seal is intimating all the partners with regard to the letter that they have received from my client.
Yes.
And my lord, apart from what he has got to know from us with regard to Somshankar not being a partner, the last line is very important. Thus, of third paragraph, my lord, page 206. The said Sujoy Mukherjee also asked us to issue no objection wakalatnama in his favor for above mentioned suit. So they know that I'm not with them. I'm wanting to come out. And that is only because I'm having a separate thought from what they are having with regard to withdrawal of the suit.
So you intimated your instruction. Thereafter, they replied that.
Thereafter, they intimated to the rest of the partners. Chatterjee
Replied you to a copy to others.
Yes, yes, yes. Then, my lord, your lordship will kindly see my present.
Yes.
Then, my lord, my present advocate on record is intimating.
This is 206.
Yes, 208 thereafter, my lord.
208.
208. This again is being intimated to the erstwhile advocate on record. My present advocate on record is intimating to the erstwhile advocate on record. Please take note that I, the undersigned, have filed wakalatnama on behalf of my above named client in the subject proceeding. Henceforth, he will be represented by me in the subject suit, and all the steps for and on his behalf will be taken by me as instructed and in accordance with law. As such, you are hereby requested not to take any step in the subject suit for and on behalf of my above named client, that is the plaintiff number 10, anymore. You are also requested not to take any step for withdrawal of the suit inasmuch as my above named client, that is the plaintiff number 10, is not inclined to withdraw the action but to proceed with the same. April. This is in April. Then, my lord, your lordship will kindly see from pages 209 to 240, my lord, there are letters written by my present advocate on record to all the parties, my lord, the partners.
How many partners are there total in your?
My lord, there are 13 partners.
13.
Yes. One passed away, there are 13. I'm one of the partners. Your lordship will kindly come to page 210. I'll just indicate one.
210, yes.
This is again, my lord, much prior to the passing of the order. I intimate to all the partners. Please take note that I, the undersigned, have filed wakalatnama on behalf of my above named client in the subject proceeding. Henceforth, he will be represented by me in the subject suit, and all the steps for and on his behalf will be taken by me, as instructed and in accordance with law. As such, you are hereby requested not to take any step in the subject suit for and on behalf of my above named client, that is the plaintiff number 10, anymore. You are also requested not to take any step for withdrawal of the suit, inasmuch as my above named client, that is the plaintiff number 10, is not inclined to withdraw the action but to proceed with the same. My lord, this has been addressed to all the parties, including the defendant Shom Shankar. Where is serial number 9? Oh. And serial number 9 is Shom Shankar Mukherjee, who, my lord, at one point of time, I admit, he was given the power of attorney to proceed. But, my lord, my case would be there has been a specific withdrawal of his right to withdraw the proceeding or take any action not to proceed with the same. There's a specific withdrawal.
On page 210 is your instruction. That is the communication of the instruction.
That is a
withdrawal of the power of attorney. Which page?
No. What I'm trying to say is, my lord, there's no formal withdrawal of the power of attorney. This particular withdrawal with regard to expression of mind with regard to my client not wanting to withdraw, my lord, your lordship, kindly see. You are also, the page 210, you are also requested not to take any step for withdrawal of the suit, inasmuch as my above named client, that is the plaintiff number 10, is not inclined to withdraw the action but to proceed with the same. So my humble submission would be before my lord that this is a specific withdrawal of that right on my behalf given to the constituted attorney not to withdraw the case on my behalf. If I'm giving, my lord, with respect, I make this submission. If I'm telling you that you have these 4 rights to perform on my behalf, thereafter I say specifically you do not have this particular right to do. That amounts to withdrawal of that particular right.
Okay, so 28/4/2025 is communication to your advocate on record. Advocate on record, as well as you see this other partners.
All the other partners.
All the other partners.
To my erstwhile advocate on record.
Erstwhile advocate on record.
By my present advocate on record, to my erstwhile advocate on record, that please note my client is not wanting to withdraw.
As well as all other partners.
All other partners. I'm giving a clear indication that I don't want to withdraw. Now, my lord, I will not trouble your lordship with regard to that the stage of the suit. That examination had commenced. Examination chief was there. Defendants had fought a lot with regard to an amendment. And all the plaintiffs, they went up before the Honorable Appeal Court, and thereafter the amendment is allowed. So that was the gravity of the suit. That was the gravity of the suit. Now, my lord, I will rely on Order 23, Rule 1, Sub-Rule 5 of the Code of Civil Procedure.
CPC টা দিন।
Yeah, hands one copy. Hand up one copy. Present. Order 23, one submit. Order 23, Rule 1, Subrule 5.
Yes.
I'll not trouble your lordship with the entire rule, my lord. I'll just go to the sub-rule. I'm just reading the headline. Withdrawal of suit or abandonment of part of claim. That is Order 23, Rule 1. May I read sub-rule 5? Nothing in this rule shall be deemed to authorize the court to permit one of several plaintiffs to abandon a suit or part of a claim under sub-rule 1 or to withdraw under sub-rule 3 any suit or part of a claim without the consent of the other plaintiffs. So, my lord, I'm heavily relying on the portion without the consent of the other plaintiffs. It cannot be done behind the back. My lord, do this in the affidavit in opposition. My lord, the main thrust of that has been thrown by the other plaintiffs is that this decision of withdrawal that has been taken by the majority of the partners. And my learned friend at the ad interim stage had relied upon Section 12 of the Partnership Act. If I may just read out Section 12.
Yes.
Because
let me see the affidavit in opposition.
Yes, my lord, the affidavit in opposition, I'm sure has been filed.
But here are the oppositions.
There are two sets. One is that by the defendants and the
I'm
other
only filing the plaintiff's set.
Yes.
You have already filed your reply
Yes. Yes, ma'am. The replies.
to all the oppositions.
No. My lord, your lordship would be pleased to take the affidavit in opposition of the plaintiffs, that is Shom Shankar Mukherjee.
Plaintiff number?
No, all the plaintiffs apart from my client, they're all the partners. My lord, page 14, your lordship will kindly come. I'll just indicate to your lordship that the point with regard to my client saying that I was not there, my decision was not taken with regard to the withdrawal has also been
The
admitted.
opposition, it is an admitted position that consent was not taken by you.
Yes.
They have taken the plea of the Partnership Act.
Majority. So this is the plea.
So this is an admitted position.
Yes, this is the plea. I'm just reading one particular paragraph.
Yes.
Page 14,
yes.
subparagraph R, small r. Therefore, from the said documents, it would appear that upon proper notice to the plaintiff number 10 and his deliberated actions to cause impediment to management and operation of the said partnership firm, the majority of the partners had decided to withdraw the instant suit. I dispute the fact that proper notice was given, that I'll demonstrate from documents. My lord, I have given reply also to that. But the fact of the majority decision having been taken by them is their case. And this is being based, and my lord, the same case has also been made out by, my lord, the defendants, if your lordship takes the other set of affidavit in opposition.
Affidavit by?
That is filed by?
No, this is affirmed by Shom Shankar Mukherjee. Yes, one of the plaintiffs.
One of the plaintiffs, and the defendant is the other set, people those were in occupation. One, Muhammad Majid Khan.
Yes.
Arekta set of affidavit in opposition.
That is Muhammad
Majid Khan.
Majid Khan.
I'm just indicating the accepted position by both the parties, both the sets. Page 5, your lordship can come. Page 5, my lord. paragraph 3, subparagraph A. The plaintiffs number 1 and its partners, being the plaintiff numbers 2 to 14, save and accept the plaintiff number 10, who constitute the majority in the partnership firm, have through their constituted attorney duly settled the disputes with the defendants and have consented to the withdrawal of the present suit. So, my lord, both the sets agree to the fact that plaintiff number 10 was not a party to this withdrawal. Now, my lord, as I have said, my lord, their case is based on the majority decision, and that is section 12.
C also, C. Page 6, C.
Page 6C. Yes, my lord.
6 of the said opposition.
Yes, my lord. I'll just see. Yes, my lord. C, the majority decision of the partnership firm. Again, B also, majority of the partners are competent. So that is the established case. There's no dispute with regard to that. Now, my lord, if your lordship kindly takes up section 12 of the Partnership Act.
Partnership Act. Yes, section 12.
May I read it out, my lord, for my lord? The conduct of the business. Subject to contract between the parties, A, every partner has a right to take part in the conduct of the business. B, every partner is bound to attend diligently to his duties in the conduct of the business. C is very important. Any difference arising as to ordinary matters connected with the business may be decided by a majority of the partners, and every partner shall have the right to express his opinion before the matter is decided, but no change may be made in the nature of the business without the consent of all the partners. And my lord, such and such, which I am not troubling your lordship with. My lord, may I just give some, my lord, emphasis on the first line? Any difference arising as to ordinary matters connected with the business. And may, it's not shall, it's may.
Usual course of business.
Yes. Now, my lord, the question arises, what is the business of this firm? Whether this withdrawal is the usual course of business or it is something not falling within the usual course of business. My lord, this was only with the intention to see that just because one partner is not consenting with the majority, the business should not be hampered. The business should go on. Now, my lord, your lordship will kindly see what has been the nature of the business of the partnership firm. For that, your lordship has to come to the supplementary affidavit that was filed on the last occasion. The partnership deed has been annexed therein.
Yes,
Yes,
affidavit in
supplementary
opposition.
affidavit. Yes, my lord. The supplementary affidavit.
Your supplementary affidavit.
Yes, my lord. Filed by Sujay Mukherjee on 21st of May, 2025. I have annexed a partnership deed, my lord.
Yes.
Page 14, running page 14.
Yes.
Under clause 3.
Yes.
This is the business of the firm.
Yes.
That the partnership business shall be of rental income and or to do such other business or business as the parties hereto may agree upon from time to time. So the business is to generate rental income. My lord, I put a question to myself, how would the partnership firm generate rental income if the partnership property is being given away to the defendant? The prayers in the suit I had first drawn your lordship's attention to. I'm wanting eviction, and they are wanting to get the suit settled by giving the defendant possession to that.
So, but in lieu of some consideration of money.
I do not know what has transpired through them. I'm wanting the suit to get
Right.
proceeded with.
Now, another
There-
question is the dispute in course of the business, arising in course of the business,
I'm obliged.
whether it falls within the course of the business or not.
And what is the business, my lord? That is the reason I'm drawing your lordship's attention to this clause. The business is to generate rent. If there is no property remaining of the partnership firm, wherefrom do I generate rent? And what they are trying to do is to give away the property of the partnership firm to the person who is illegally claiming the property. 2 godowns of 1,700 square feet on Portuguese Church Street. Your lordship can imagine the value of the property.
Earlier, they were just occupiers. They did not pay any rent.
They were
Earlier-
given as caretakers. That is our
Caretakers.
case, yes. They were given as caretakers. We wanted to get them removed. We don't want you to stay there anymore. Then they came up with the case, as I indicated in the written statement, that they are becoming direct tenant from that of the Waqf estate, which means that my right of tenancy over the property goes, the partnership's right goes, they become the direct tenant of the Waqf property estate, which all the plaintiffs are wanting to accede to. Your lordship can very well imagine. After having taken so much of step, after having fought right up to the appeal court with regard to an amendment, after having commenced the trial of the suit, why such a thing is happening? And that is what I am not interested in. Now, my lord, the prayers in the plaint, I will not trouble your lordship. So this totally goes against the benefit of the partnership firm. And my lord, this is not a decision which is taken for the running of the business of the partnership firm, as a result of which the majority decision would not apply here. If the majority decision, which is taken to be an exception to Order 23, Rule 1.5, is not applicable, then we have to fall back on Order 23, Rule 1.5, which says that all the plaintiffs' consent has to be taken. Now, my lord, one more section, if I may trouble your lordship with, is from the partnership firm, is Section 9, and my lord, Section 19 as well. Please. Section 9 and Section 19.
Yes.
Section 9. Partners are bound to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render true accounts and full information of all things affecting the firm to any partner or his legal representative. So it is the common advantage that has to be taken care of. Here, my lord, that is not being done. It is for some personal advantage that this step is being taken, which I am opposed to. And my lord, Section 19 once.
Yes.
My lord, implied authority of partner as agent of the firm. Subject to the provisions of Section 22, the act of a partner which is done to carry on in the usual way, business of the kind carried on by the firm binds the firm. The authority of a partner to bind the firm conferred by this section is called his implied authority. Subsection 2. In the absence of any usage or custom of trade to the contrary, the implied authority of the partner does not empower him to, my lord, I am just indicating C and D. Does not. C is compromise or relinquish any claim or portion of a claim by the firm. D is withdraw a suit or proceeding filed on behalf of the firm.
Yes, that means if an authority is given to a partner to run the business, it implies that he can file suits also, but he
Can't
cannot
withdraw.
withdraw the suit. So this is one thing. A particular partner given the authority to take steps, but he is not given the authority to withdraw the suits. But to some extent, there is a slight difference, because here the dispute is that merely majority of the partners' decision will not empower the firm to withdraw the suit. That is your case.
That is my case.
Simpliciter majority does not mean that there is a power to withdraw the suit,
I'm
unless
obliged.
all partners consent.
I'm obliged. In addition, coupled with that, my lord,
Yes.
even if there's an implied authority that you please take steps with regard to the running of the business,
This is applicable to a particular partner
maybe as your lordship,
or one or two. But here, most of the partners agree
Majority.
except one.
majority,
So the earlier, that is section 9 probably,
section 12.
section 12, whether it attracts section 12 or not.
I'm obliged. I'm obliged because that has been the sheet anchor of their submission.
No, this is
That
also there, but it is case of a particular partner given authority, whether he gets power or not.
And my lord, I'll trouble your lordship only once with the terms of settlement. Is that a part of the petition? Oh, my lord, in the affidavit in reply filed by my client to the opposition filed by the plaintiffs, my lord, the terms of settlement is there. Good, Papa. My lord, the terms of settlement starts at page 52, my lord, and the relevant portion. Page 60, my lord, the relevant portion. Come to the top. What I'm trying to, my lord, espouse before my lord is that from the terms of settlement, your lordship will kindly see that page 60, my lord, are the terms.
Yes.
60
It
and
starts from
61.
page 60, 61.
Page 60 and 61. Nowhere from the terms of settlement, your lordship will kindly see that there is anything which would be benefiting the partnership firm. If I may read out, if your lordship so wants, my lord, I'll read out. The plaintiff number 1 instituted the present suit being such and such inter alia seeking eviction and mean profit. Several applications were filed in the said application and there has been protracted litigation between the parties. In the said suit, Mr. Such and such advocate appointed as receiver by an order dated such and such for the purpose of carrying on inventory of the suit premises. Next, by an order dated 27 January 2014, passed in GS such and such, this Honorable Court directed the defendants jointly and severally to deposit a sum of rupees 50,000 per month with the receiver as occupation charges without prejudice to the rights and contentions of the parties, and the receiver will invest the same after every 2 months in a term deposit with State Bank of India, High Court Branch, Kolkata, earning the highest rate of interest. Accordingly, the defendants have deposited a sum of rupees 21 lakh with the receiver on various dates and has been invested in term deposit with State Bank of India, High Court Branch, Kolkata. Presently, the instant suit has been pending at the stage of examination of the plaintiff's witness. The plaintiff's witness was examined in chief as on 4th of July 2018. Mr. Somshankar Mukherjee has been authorized on behalf of the parties in the present proceeding to act and take steps on behalf of the parties. No progress in the suit has taken till date, and cost of litigation and other expenses have become onerous on the parties, and it would be in the interest of the partnership firm that the suit be withdrawn. Here I pause for a moment, my lord. I put a question to myself. He is the constituted attorney. What step has he taken since 4th of July 2018 to proceed with the examination in chief? The examination in chief had already started. Your lordship has shown your lordship orders way back in 2015. It was observed by this honorable court that the suit is ready for trial. Again, it was repeated in 2017. What steps have been taken? During pendency of the suit, the parties have thus amicably resolved their difference. The minutes of dated 1st February, it was agreed on behalf of the plaintiffs to withdraw. I was not a party to this minutes.
The meeting held for the purpose of withdrawing the suit, Is the resolution annexed to this affidavit in opposition?
Uh,
Resolution taken in
they
the
have
meeting?
annexed. I'm not a party to that.
Anyway,
I'm not a party to that. I was not given any notice with regard to that. Prior to that, I was given notice. I've answered why I have not attended.
because both this has to be taken into consideration, that
As your lordship,
resolution.
I will. As your lordship,
There
I will.
you are not a party and defendant definitely will not be a party. No question.
I suppose so. I do not know. I suppose so. My lord, and one more, my lord, point. Their main trust is on the point of the suit is becoming onerous because of the expenses. I, my lord, call upon them, the other partners, the plaintiffs, to produce one evidence with regard to the expenses being borne by the partnership
It
firm.
was filed in the year 2014,
It's a suit of, my lord, 2013.
13. And within a period of 5 years, I think, it reached the examination in chief.
Yes, and my lord, 2014 it was observed, suit trial, ready for trial. Within 1 year, it was ready for trial. An examination in chief, my lord, commenced. My lord,
Yes, 4th July 2018.
Yes.
As per their settlement agreement.
At page 122 of the petition, my lord, I've indicated to your lordship that the examination in chief started in 2018. Suit was ready for trial. In 2014 itself, within 1 year. And now they're saying that protracted litigation and onerous. And my lord, I call upon the plaintiffs to produce one scrap of evidence to show that any amount of expenses with regard to this litigation has come out from the partnership firm. Let them show. That is the main reason.
So you see, expenses of the suit are to be borne by the fund.
Partnership firm.
So if the partners are benevolent, that the funds are very meager, they can bear it from their pocket also.
That has not been the case in the terms of settlement.
If they are very much benevolent. Yes, if it is meager, I'll bear it from my pocket.
That is not their case, my lord, that it's meager. They are saying it is onerous on the firm. My lord, that is the partnership, that is the deed, terms of settlement.
No, you see, if suit is pending, definitely expenses will be incurred, either from their pocket or from the partnership fund.
My lord, but that has not been the case made in the...
Anyway, the terms of settlement does not say so.
The terms of settlement does not say at all. Yes, and my lord, your lordship will kindly see the following clauses. Clause 8 is with regard to the minutes in which the resolution has been taken by them. I was not a party. Then 8.1, the suit be withdrawn unconditionally against the defendants. How will I put a question to myself, how will the partnership firm gain? By giving the property away to a third party. Is that the gain of the partnership firm? Then all interim orders passed in the suit are vacated, the learned receiver appointed in the instant suit be discharged, and the term deposit in the said suit be released in favor of the defendants. What a clause, your lordship will kindly see. Plaintiffs are so benevolent that they are wanting to help the defendants in getting the amount. Even if the defendant has deposited this amount, this was deposited pursuant to orders passed by this court for occupation charges. I put a question to myself, why would the occupation charge be given back to him? 21 lakhs. He would stay free of cost. He would get the money back. The defendant shall continue to use and be in occupation of the suit premises. The parties shall bear the respective cost of the proceeding. Save as aforesaid, none of the parties shall have any right or claim against each other.
Regarding the cost of the proceeding, it is to be borne by the parties. That is there.
Parties shall bear the respective cost of the proceeding, yes. But with regard to clause 6, your lordship will kindly see that has been the main 6. Numerical 6, page 61. That is the main reason.
Yes.
No progress in the suit has taken place till date. I do not know why. And cost of litigation and other expenses have become onerous on the parties, and it would be in the interest of the partnership firm that the suit be withdrawn. So, my lord, if it is the parties who are bearing the expenses, then it cannot be onerous on the partnership firm not to continue. The parties would keep on continuing with the payment. So, my lord, this cannot be true, and your lordship will kindly see the amount of favor that is being given to the plaintiffs, defendants. Also, the amount which is deposited at occupational charges pursuant to order of court is also been given back to them. So what has weighed that last
21 lakh, just a minute.
21 lakhs is not
21 lakh.
written.
Deposited. The question is, this is the yes. Now, what will happen to the 21 lakh?
They will get back according to the terms of settlement, paragraph page 62.
Right, right. 62 term deposit said.
The said should be reviewed in favor of the defendants. Page 62, first line. Defendants were paying occupational charges that was deposited with the receiver pursuant to the direction given by this honorable court. So even if a suit is being withdrawn, the partnership firm is entitled to get that because they have been occupying the partnership firm's property all this while. That is the reason this honorable court directed occupational charges to be paid. Now that amount of occupational charges which was deposited with the receiver is also directed to be paid back to the defendant. So your lordship can appreciate and your lordship can imagine what has been the amount of consideration that has flowed. Why such a favor is being given to a party against whom all this while I was fighting tooth and nail? All of a sudden there has been a change of view. So my lord, for the moment, my lord, after my learned friend makes the submission, I'm sure your lordship will give me an opportunity of replying. My lord,
After the other plaintiffs,
Because
12:30 I fixed the matter.
in reply, he's only going to reply to technical points.
Yes.
If he has any submission, let him finish it.
No, but
Now
then,
the question is, you see, at 12:30 I fixed the matter.
That's fine. That we can come
then
tomorrow.
your lordship will
After hearing the submission of the defendants and the other plaintiffs,
Yes, yes.
because after all, you have to submit your written notes of arguments also.
as your lordship.
All I'm saying is factually and legally, if my learned friend wants to cite anything or make any further submissions, let him do it. Because in reply to my submission, he'll only be allowed
my lord,
classically.
Yes,
No, no,
Sorry,
reply,
legal
no new
points.
points, only points of law.
Yes.
it is very justified.
So he said, I will.
Fine.
That's fine.
That is very justified, my lord. Then your lordship will kindly give me 10 more minutes time, some more factual aspect I have to, with regard to the notice. They have said that the resolution was taken on 1st of February. My case is, my lord, since much before 1st of February, I was totally in the dark.
Anyway, you prepare your written notes of arguments
I'll
on the next day with a compilation
Well, let it be tomorrow.
of the list of dates and the decisions. Okay.
Well, my learned friend has almost concluded. It will take him 10 more minutes. I'm absolutely ready, my lord. I will advance my. Today I would have finished.
Yes, instead of 10 more minutes, you better get your written notes of arguments ready.
Yes.
As your lordship,
I
please,
would
and my
have
lord,
completed today, but your lordship has fixed some matter.
my
at
learned friend on the
12:30.
last occasion has cited one judgment.
No, no, he will also submit his written notes on the next
My lord, with regard to the judgment, your lordship will kindly allow me to distinguish the judgment.
করে দিন না আজকে, এখনো সময় আছে।
I'll do it. If your lordship allows.
12:30 have.
ঠিক আছে, এখনো 5 মিনিট আছে, করে দাও না।
May I distinguish the judgment, my lord, and then I'll come with the.
It's
written
better
note.
if you do it in your written notes.
As you know, and then I'll do it. I'll do it.
Exchange your notes also.
I'll do it. As your lordship.
But my lord, kindly, my lord, keeps it tomorrow, my lord. The matter is absolutely fresh in the court's mind. We'll come tomorrow.
Tomorrow you have any difficulty?
I don't have any difficulty. I've got matters fixed before my lord.
Learned advocates for the petitioner and learned advocate for the opposite parties are present. Third learned advocate for the petitioner in GA 11 of 2025. Mr. Ghosh, learned advocate, Mr. Shonendu Ghosh, learned advocate for the petitioner, concludes his arguments and he may further clarify and submit his written notes of arguments on the next date fixed. Learned advocate appearing for plaintiff number.
Plaintiffs, all plaintiffs,
Apart
7
from
except.
Which opposite party you are appearing now?
All plaintiffs, apart from Mr. Shonendu Ghosh's client.
Okay. Mr.
Majority.
Plaintiff up 1 to 9, I believe.
Learned advocate appearing for
1 to 14, 7 except 10.
appearing for plaintiff number 1 to 9,
1 to 14.
1 to 14,
Or 1 to 9 and
1 to
11
9.
to 14.
1 to 9
and 11 to 14.
and 11 to 14. 6 time to submit, to argue the matter.
But can it be, your lordship, if your lordship's diary permits, on Monday? Then we'll come with the notes also. My learned friend will get some. Everything.
Yes. Better come with your notes. It
My
will
lord,
expedite
Monday,
the matter.
Monday, if your lordship.
Let this matter appear on
23rd.
Tuesday, Tuesday.
Tuesday नहीं है ना सब.
Monday नहीं. My lord, can it be on Wednesday then, my lord? My learned junior is in some difficulty on Monday. My learned junior.
Okay.
But I will
25
argue, but ठीक है.
My lord,
25/6/2025 at 12:30 PM.
Yes,
as your lordship.
lordship.
আচ্ছা 1 মিনিট 25 তারিখে ওই 12:30টার সময় কোনো ম্যাটার 12:30টায় কোনো ম্যাটার ওকে
Hello, deeply.
25/6 at
My
12:30
lord,
PM.
so deeply obliged. Well, let it be indicated in the list. Well,
Yes,
today
yes,
also it was supposed to be at
The
12:30.
interim order is to continue, my lord.
12:30 25 তারিখে.
My lord, the interim order is expiring today.
Okay. The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Deeply obliged.
এই বেলা ডিসিশন হয়ে গেলে কিন্তু আর পাও এই বেলায়
Deeply obliged, my lord.
Item number 2 with item number 3.
Appear for the plaintiff.
তাহলে এদিকে চলে আসো, উল্টো দিকে চলে আসো।
আচ্ছা, আমরা এদিকটা চলি, তোমার সুবিধা হবে এদিকটা।
যখনই অসুবিধা মনে হবে আমাকে থামিয়ে দিও। জিজ্ঞেস করবে।
Yes, Mr. Dhar, today the witness is present. Yes.
ফোন করো। ফোন করো। Speak English?
हिंदी।
आपके आज पहली बार गवाही देने के लिए आए हैं?
हाँ जी,
ठीक है।
पहली बार।
मेरे साथ बोलिए। हम धर्म से कह रहे हैं
हम धर्म से कह रहे हैं
इस मुकदमे में
इस मुकदमे में
गवाही के तौर पर
गवाही के तौर पर
हम जो कुछ भी बोलेंगे
हम जो कुछ भी बोलेंगे
सच बोलेंगे,
सच बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे
सच के सिवा झूठ नहीं बोलेंगे
और कुछ नहीं छुपाएंगे।
और कुछ नहीं छुपाएंगे।
आपका नाम,
किरण व्यास।
स्पेलिंग बताइए।
उतना नहीं याद है।
My lord, she cannot give any evidence
Why? Yes.
because, my lord, in this probate proceeding,
Yes.
there are many persons who had given consent. She has also given consent in granting probate. So therefore, she cannot give any evidence.
आपका नाम
That will be taken into consideration.
No, not consideration, my lord.
No,
She
you put
doesn't
it-
have any right of audience.
Put it in your cross-examination because
Oh, I am making
बड़ा
this
नहीं,
point as a preliminary point
आपका नाम लिखिए पहले।
that a witness who has come before the court to give evidence against the grant of probate,
या पिताजी का नाम
she herself has given consent
नीचे
for
इसके नीचे
allowing this probate proceeding and grant
हिंदी
of
में नहीं, इंग्लिश
probate.
में।
yes,
So therefore, she cannot give any evidence.
सही नहीं आता।
बोलिए क्या नाम है?
this preliminary objection will be recorded. Okay, your
My lord, not only recording, my lord, kindly consider, lordship kindly decide this issue that whatever she says, anything contrary to
are you disputing her consent?
it cannot, she cannot, he cannot consent.
Well,
It
you
is
already
not-
produced, but which has been already an application was placed, the caveat was lodged, but due to limitation, it was filed after the limitation.
Question is, if you are not,
I am placing you.
So therefore, she is not.
anyway, you see, later because she has come later, depose if your application or your point is allowed. You take out if your application is allowed, it will be all expunged.
Yes.
Entire thing will be expunged.
My lord, if your lordship
passes such order that her evidence should be expunged, in that case, there is no point of taking the evidence. My lord, my point is that
But if your application does not say,
it is not my application. Kindly appreciate this. Just a minute. Just a minute, Mr. Dot.
She may agree with the
No, I do not. I cannot. I cannot proceed on presumption. It is not on presumption. Kindly sees that a probate proceeding, Lordship knows the law, that the heirs and legal representatives of the deceased either can give consent to the grant of probate or can oppose the grant of probate. Those who gives consent to the probate, they just give their consent and they do not file any caveat. But those who do not oppose, they have to
undue influence.
Is it a law? What are you saying? Consent given. There is a after that. No. My lord, kindly don't allow this witness to give any evidence. Kindly, because first of all, she did not file any caveat.
My landed friend is so afraid about the witness
because first of all, she has given consent. Secondly, she did not file any caveat. Without filing any caveat, she wanted to.
The caveat, he filed a caveat which was not taken as it was under limitation. Limitation period.
So that is the order dated 24th.
It was also.
Mr. Dhar, kindly speak something which is sustainable in law.
No citation was served upon her.
My lord,
whatever is
after
is also pending. I am not talking about that.
Please.
Order is also pending.
Please.
Pending before the division bench.
which order?
In which his prayer was refused for filing the caveat after the grant of probate was applied for. Is still pending.
So therefore, let the appeal be disposed of.
It would not be proper for this court to proceed.
That's
at
right.
this stage.
That's
Yes,
right.
give me that order, please.
This is the order, my lord. Kindly, this is the order. And this order, according.
What is the present state?
Initially, it was application for grant of probate.
Okay, let me see.
But on
I ordered
the
down.
death of all the executors, if the proceedings has been transformed for letter of administration.
So
which is also opposed.
So it's better you come with necessary application if you want some modification or if you want her to depose. Okay, I'm adjourning the matter.
My lord, kindly read that order.
Be recorded.
No,
Evidence of the
nothing.
witness be recorded.
Nothing.
It's better you take some application from her.
My lord, kindly sees the order dated 24th August 27.
She is witness, independent witness.
No, question.
For the
Actually, order telling order.
Yes, order dated
24th August 2017. My lord, may I?
Filed by whom? This application?
Huh?
This application?
That lady wanted to file caveat after the time was lapsed. My lord, may I read this portion? Kiran Vyas, who earlier gave consent. My lord, that copy out, Alexa.
Yes, 24th August.
My lord, may I get kindly, may I have that order? Kindly, so that the lordship can come to the main point of that order.
Now the caveator has called this person to put a depose for her. The position is totally different. Initially, he applied for filing of the caveat, having objection.
My lord, kindly says.
She has come to depose on behalf of the for the caveator.
Kindly says the Kiran Vyas.
This is your list of dates. Let me.
The ordering portion I have quoted. That's why, my lord, I have. The order is also Kiran Vyas, who earlier gave consent affidavit, filed two applications, one for leave to file caveat and to contest the probate proceeding, stay of probate proceedings, and other for stay of order dated 29 November 16, passed by Honorable Justice Sanjeev Banerjee, granting Ranjana Sequal to be substituted as applicant under the letters of administration with will annexed. Upon hearing, Honorable Justice Somen Sen rejected both the applications of Kiran Vyas by order dated 24th August. That is the order which I have handed over to your lordship.
Okay, this is
The
24.
order is
24th August
challenge and
27.
appeal is pending.
Anyway, let the appeal be
10-1, 2018, what is this?
24th August 2017.
No,
Then
thereafter,
January 2018, next page.
10-1, 2018.
Kiran Vyas again filed an application for filing caveat and removal of Ranjana Sequal as she is
My
not
lord,
taking proper
Since
steps.
this
preserve
witness
the
is not
property.
appearing as a party, there is no bar for adducing evidence on behalf of the caveator.
She
By
cannot.
that time, while the caveat was, she intended to file the caveat, and by that time, it was become the contentious cause by an caveat of the Chandrakala Sharma, who is the caveator presently. And on behalf of, in support of the Chandrakala Sharma, this witness has come independently being a witness, not as a party. There is no such bar. And for deposing by a witness on behalf of the caveator or the defendant, there is no provision to file an application for praying for permission of the honorable court.
Okay,
There is no such provision.
distinguish this provision of law. I am keeping it.
My lord,
Yes.
my lord, may I suggest one thing?
Yes.
May I suggest one thing? My lord has recorded my submissions, my preliminary objection with regard to her giving evidence in the matter because she has already given consent and she wanted to file caveat by changing her mind at the subsequent stage, which was rejected by this court.
No, there
That-
is no question of
First-
changing this her mind.
No, what is her?
She is
no,
not
with-
coming. She is not.
Either you
coming. What
listen to me or you do not listen to me.
Chandrakala Sharma, the caveator in this contentious cause, has called her to adduce witness.
No, my lord.
We adduce evidence.
Well, let me complete, my lord.
How the question
Every
is
time
coming
if somebody interferes, my lord, then it is difficult to go on the proceeding. So, my lord, that is the position. Lordships can record my submissions, my preliminary objection to that, and without prejudice to my rights and contentions, let her give evidence, whatever she wants to say.
Your
But
lordship
that has to be recorded
already
first.
suggested that.
No, that has to be recorded first.
Yes, yes,
I am accepting the court suggestion.
yes, yes, yes.
I am accepting the
Definitely, I
court
have to
suggestion.
record that.
Kindly record.
In any case, if my learned friend has any objection, it may be
Because
recorded and we
That
can
means you cannot
decide
cross-examine her.
I am
Yes.
No. If that is okay, anyway, because if it has to be up to this examination in chief stage.
I will do that. I had only said that she does not have any right to give any evidence because she has not filed any caveat, and number two, she wanted to file caveat at the latter stage, which was rejected by the
I will
court.
hear this
By
point.
that time,
I'll record your objection and keep it for further arguments on some other day. In the meantime, let her depose.
My lord.
Yes.
my lord, kindly.
Anyway, please you complete the deposition. Thereafter, I shall hear on the points of law.
Thereafter, we will decide.
No, I will have the right of
Yes,
procedure.
yes.
May you open.
Yes, sir. Yes.
Your name.
आपका नाम बताइए.
किरण व्यास.
किरण व्यास.
Madam, please tell my lord in which language you are comfortable to depose.
किस भाषा में आप बोलना चाहेंगे बताइए मैडम.
हिंदी भाषा में.
In Hindi. I would like to depose in Hindi.
Automatically.
Madam, how you are related with Kanhaiya Lal Sharma, Kanhaiya Sequal or Pandit?
कन्हैयालाल शिखवाल से आप कैसे संपर्कित है बताइए.
कन्हैया लाल जी मेरे पिताजी थे और मैं उनकी बेटी हूँ.
Mr. कन्हैयालाल शिखवाल
की लड़की हूँ मैं.
is my father and I am his daughter.
Are you the only daughter of Kanhaiya Lal Sequal?
आपके एकमात्र
बेटी है कन्हैयालाल सिख?
नहीं, हम 3 बहनें हैं, मैं बीच की हूँ,
No,
सेकंड नंबर।
we are 3 sisters and I am the medium one, middle one. I'm the middle daughter of him.
Madam, please tell my lord that for which purpose you have come in the court.
आपकी किस वजह से आज कोर्ट में आई है, ये माय लॉर्ड को बोलिए।
मैं वसीयत के बारे में गवाह देने के लिए कोर्ट में हैदराबाद से आई हूँ।
I have came from Hyderabad to this court to depose regarding the will of my father, Mr. Kanhaiyalal Shekhwal.
To give गवाह देने के लिए, to give evidence.
Give evidence regarding the will of Kanhaiyalal Shekhwal. बानान टेकन पे ये भी है।
For whose support you have come to depose in this case?
For whose?
For whose support she has come, you have, yes, for whose support you have come to depose in this case?
किसको समर्थन करने के लिए आज आप यहाँ पर गवाही देने के लिए आए हैं?
मैं चंद्रकला शर्मा को सपोर्ट करने के लिए आई हूँ।
I have came to support Chandrakala Sharma. I have come to support her. Chandrakala Sharma. Yes, मिसेस की कोई जान वो बोले नहीं तो किसी I have came to give evidence in support of Chandrakala Sharma.
Can you tell my lord in respect of which case you have come to depose?
किस केस के सिलसिले में आज आप गवाही देने के लिए आए हैं, माय लॉर्ड को बोलिए।
के लिए मैं आई हूँ।
किसकी वसीयत?
कन्हैयालाल जी सिखवाल के।
I have came today to depose before this court, before this honorable court, regarding the will of Mr. Kanhaiyalal Shekhwal.
Who called you to depose?
किसने आपको कॉल किया था गवाही देने के लिए?
चंद्रकला ने।
Chandrakala
शर्मा।
Chandrakala Sharma called me to depose before this court in this matter.
What's her position in this case, in this suit?
चंद्रकला शर्मा आपने बोला, उनका क्या पोजीशन है इस केस में? वो क्या है? प्लेंटिफ है, डिपेंडेंट है, क्या है वो?
ऑब्जेक्शन के लिए कहा था, ऑब्जेक्शन विल के लिए, वसीयत के लिए।
नहीं, आपने समझा नहीं। चंद्रकला शर्मा का पोजीशन क्या है? एक मामला होता है ना, कोई मामला कटता है, किसी के अगेंस्ट कटता है,
वो वसीयत के ऑब्जेक्शन के लिए।
Anyway, record whatever.
Record it. Record her answer.
आपने क्या बोला? फिर से बोलिए एक बार। चंद्रकला शर्मा।
वो वसीयत की ऑब्जेक्शन के लिए।
Chandrakala Sharma raised her objection against this will. Raised her objection against this will.
What's your educational qualification?
आपने कितना दूर तक पढ़ाई किया है, बोलिए।
श्री डोंगरगढ़ में 7वीं कक्षा की, राजस्थान में बीकानेर के पास 7 क्लास।
I read up to 7
class.
I read up to 7th grade.
Rajasthan Bikaner.
at Rajasthan, Bikaner.
श्री डूंगरगढ़
जितना पूछा जाए उतना ही बोलिए, ज्यादा कोई जरूरत नहीं है।
নামটা নিয়ে নিন, ওটা নামটা তো
राजस्थान बीकानेर स्कूल का नाम बोलिए।
बालिका शिक्षा सदन
बालिका शिक्षा सदन, फ्रॉम द स्कूल नेमली बालिका शिक्षा सदन,
জায়গাটার নামটা বলুন।
राजस्थान बीकानेर।
ডুঙ্গারগড়, ডুঙ্গারগড়টা জায়গার নাম, ওটা লিখে নিয়ে নিন, বলছে যেটা।
फुल बोलिए, बालिका शिक्षा सदन
श्री डूंगरगढ़
श्री डूंगरगढ़, डूंगरगढ़
बालिका शिक्षा सदन।
ओके, बालिका शिक्षा सदन, ये कहाँ पर है? राजस्थान बीकानेर में है।
डूंगरगढ़ में, बीकानेर के पास श्री डूंगरगढ़ में है।
शिक्षा सदन,
डूंगरगढ़ में।
द स्कूल नेमली श्री डूंगरगढ़ बालिका शिक्षा सदन एट डूंगरगढ़ नियर बीकानेर, राजस्थान। ठीक है?
हाँ ठीक है।
यस सर।
In which medium you have been educated?
आपने कौन सी मीडियम में पढ़ाई किया है? बंगाली, हिंदी, इंग्लिश, ऐसे?
के अंदर
हिंदी मीडियम।
Can tell my madam, please tell my lord that whether you can read English or write English.
क्या आप इंग्लिश पढ़ लिख सकती है?
नहीं।
नो, आई कांट।
खाली साइन हिंदी में अंग्रेजी में करती हूँ।
आई कैन ओनली साइन माई नेम इन इंग्लिश।
Please tell my lord that in which language you can read and write.
कौन सी भाषा में आप पढ़ लिख सकते हैं, बताइए माय लॉर्ड को।
हिंदी भाषा में।
इन हिंदी आई कैन रीड एंड राइट। आई कैन रीड एंड राइट इन हिंदी।
Question answer নিচ্ছেন তো? Please tell my lord that the educational qualification of your father Kanhaiya Lal Sikwal.
कि पिताजी ने कितने दूर तक पढ़ाई किया है वो बताइए।
दूसरी क्लास।
माय फादर read up to class 2. up to the second grade করতে পারিস।
Please tell my lord in which language your father used to read and write.
आपके पिताजी किस भाषा में पढ़ते थे और लिखते थे कुछ भी?
मेरे पिताजी हिंदी भाषा में पढ़ते थे और हिंदी में ही
लिखते थे,
थोड़ा लिखते थे।
My father used to read and write in English, in Hindi. In Hindi.
Please tell my lord whether your father Kanhaiya Lal Sharma was able to read English.
आपके पिताजी क्या इंग्लिश पढ़ सकते थे?
नहीं।
No, he can't.
Please tell my lord whether he was able to write English.
क्या वो?
No, that is a leading question. If you put these questions in this way, whether he can do or not, it amounts to leading question.
No, your lordship, that this is not leading question. That is, I am talking about a particular language. He, the testator, used to read and write in Hindi. about knowledge
He
about
put in
the
some other
reasons.
manner, whether he, apart from Hindi, whether he could understand any other language. There could have been put in some other way, other than
My
by
lord,
way
my
of a
lord,
leading
my lord,
question.
my lord. I am reframing the question.
My lord,
I am reframing it.
Anyway, let it be recorded.
my lord, ওই প্রশ্নটা থাকবে না বাদ যাবে?
Okay.
প্রশ্নটা বল একবার।
Yes.
Should I reframe the question?
Anyway, put some other questions.
বাদ যাবে তাহলে।
Anyway, let it be there.
Disallowed.
কোশ্চেনটা থাক ডিজার্ভ।
Madam, please tell my lord, other than Hindi, your father, late Kanhaiya Lal Sequel, used to read and write any other language?
This is also
हिंदी को छोड़कर क्या आपके पिताजी कोई और भाषा में लिख या पढ़ सकते थे?
This is also my lord a leading question. My lord, kindly object. I am objecting to this.
और भाई बंगाली में थोड़ा बोलते थे, थोड़ा थोड़ा।
My father used to talk in Bengali. No, used to talk little in Bengali. Used to talk a little in Bengali. My father used to talk a little Bengali.
थोड़ा थोड़ा समझते थे यहाँ बंगाल में आने।
Hiran Vyas. ये फोल्डर आपका है ना?
Do you know any language? Do you know the languages in which you read and write? Some of the languages in which your father used to read and write.
Madam, please tell my lord that whether you know your father used to read and write in any other languages?
क्या आप
Type of question is
क्या आप जानते हैं कि आपके पिताजी और कोई भी भाषा लिख या पढ़ सकते थे या नहीं?
हिंदी के सिवा नहीं लिखते थे, खाली हिंदी।
My father did not.
My lord is giving this leading.
My father did not know any other language apart from Hindi.
Kindly disallow.
I am asking the whether
no,
except
You
Hindi.
have asked the previous question was that whether he knew other language or not. She replied that.
Replied.
Again, what is the?
So why again you are putting that question?
That is, I think that has been disallowed.
No.
That has not been disallowed.
Oh, then
Yes, earlier one is recorded.
Yes. So this question should be disallowed.
Don't put the second question because you have already put that.
Yes.
To confirm করো আমি বুঝতে
No, I thought it has been disallowed.
বলো next question.
এই আগের কোশ্চেনটা পড়ুন তো কি আছে আগেরটা? What is the previous question?
উঠে বল।
Okay, so previous question is there. So second question is not necessary.
Not required.
Second question be deleted.
সেকেন্ডটা পরেরটা।
Last question.
The second one, last.
আপনি যেটা নিলেন প্রথমটাই ডিলিট করুন।
হয়ে গেছে?
না, আচ্ছা। Madam, can you tell my lord in which language your father used to sign?
आपके पिताजी किस लैंग्वेज में साइन करते थे?
हिंदी के अंदर।
इन हिंदी। माय फादर यूज्ड टू साइन इन हिंदी। दस्तखत करते थे।
Madam, please tell my lord whether you are able to identify signature of your father on any document.
माय लॉर्ड को बोलिए, क्या आप कोई भी डॉक्यूमेंट में, कोई भी दलील या दस्तावेज में आपके पिताजी का दस्तखत जो है वो क्या आप पहचान सकती है?
हाँ, पहचान सकती हूँ।
यस, आई कैन आइडेंटिफाई।
My lord, the exhibit is to be produced. Exhibit 8. পুরো exhibit একই সঙ্গে বোঝা যাচ্ছে।
পুরো ফাইলটাই দাও।
Exhibit 8.
So that is probably yet annexed with the petition. Exhibit A is annexed with the original application. একদম
সাবধানে
একবার অনেক
আবার কোনা ছিঁড়ে পেরিয়ে গেছিল, কোর্টে প্রচুর কষ্ট করে খুঁজে পেয়েছে।
না,
হ্যাঁ
হ্যাঁ হ্যাঁ হ্যাঁ।
খুব সাবধান।
আবার ভাঁজ খেয়েছে।
আজকে স্লো হচ্ছে।
ও পেছনে কাগজ কাটবে।
আমার একটু টাইপ হচ্ছে না,
সিগনেচার
ওই তো দেখি না।
সিগনেচার
আর একটু 4 বছর হয়ে গেল।
I don't person now. I'm showing you.
My lord, I am showing A1 to the witness. এটা খুব সাবধানে।
এক্সিবিট A1।
এক্সিবিট
কোন এক্সিবিট?
ভাঁজ করবেন না, খুলে রাখ।
খুলে রাখবো? ওকে।
হ্যাঁ খুলে রাখ।
ফেটে যাবে।
ফেটে যাচ্ছে, ফেটে যাচ্ছে।
ওকে ওকে। Yes sir, what is the question?
এক্সিবিট A1 টা
Shown exhibit A1.
shown exhibit A1
Shown exhibit A1 A
A1
এখানে A
না না না
আচ্ছা আচ্ছা সরি
এ পরে আসছে। ম্যাডাম, please tell my lord whether you can identify the
No. Whether you can একদম জানি।
Madam, can you identify whether this is your father's signature?
No, no, she should identify which is the signature of her father. Okay.
না ওটা এটা already exhibit.
No, no,
It
no,
is
no.
it is already exhibit.
So
এটা
let her show which is the signature of her father. There are other signatures also. From
I
that
am coming to that.
Yes, yes.
After this, I will come to that.
After this,
No, no, you have put the question that she knows whether she knows the signature of her father. She says yes, so you can ask her which is the signature.
Madam, do you find the signature?
কোশ্চেনটাই ফ্রেম হচ্ছে
কোশ্চেনটা বাজিয়ে নতুন
এটা যায়নি. Do you find the signature of your father in this page of this document?
क्या इस पन्ने में आप आपके पिताजी का कहीं पर दस्तखत देख पा रही है?
नहीं,
नो.
वो हिंदी में करते थे इधर
फादर यूज्ड टू साइन इन हिंदी.
Yes, let it go. No, no, let it be recorded.
Yes. Grateful, Your Lordship. The next page.
On the next page. Then
In the next page.
Yes.
Question remains the same.
In the next, madam, can you do you find any signature of your father in the next page?
क्या इस पन्ने में आप आपके पिताजी का कोई दस्तखत देख पा रही है?
इसमें तो दस्तखत नहीं दिख रहा पिताजी का.
No.
वो इंग्लिश में करते ही नहीं थे.
No, I cannot find any signature of my father in this page. My father did not use to sign in English.
In that case, Your Lordship, the exhibit A has to be shown. This is
Yes,
exhibit, entire exhibit A.
No, no, you show her, but whatever is required to show, you show her.
The first page and second page.
যেটা এক্সিবিট হয়নি সেটা কোথাও দেখা
এই দুটো page. এটা তো এটাই তো এ.
ব্যাস আর কিছু নেই, দুটো পাতাই।
এবার দেখিয়ে শুনুন, এটা প্রশ্নটা হচ্ছে, please show the exhibit A. Exhibit A is shown.
Yes.
Please.
ये नहीं है पिता.
Please try to have patience. Madam, do you find any signature in the entire document which you have placed for you before you? Signature of your father. Do you find the signature of your father in the entire document?
Yes, explain her.
That is exhibit.
Explain her in Hindi.
एग्जिबिट ए पे ना पूरा डॉक्यूमेंट है?
पूरा एग्जिबिट, खाली एग्जिबिट ए थे.
क्या इस एग्जिबिट ए जो है इसमें आप अपने पिताजी का कहीं पर भी दस्तखत देख पा रही है? देख कर बोलिए. एग्जिबिट ए ये है, यहाँ से शुरू हो रहा है, ठीक है?
नहीं, इसमें है ही नहीं.
आप देखिए, पहले पूरा डॉक्यूमेंट देखिए.
ये एक जगह है पर ये नहीं है पिताजी का साइन. वो हिंदी में करते थे.
At the bottom.
You just tell my lord whether there is a signature of your father.
At the bottom of the first page of Exhibit A, there is a signature, but this is not the signature of my father as he used to sign in Hindi.
This is not.
I find the signature appearing in that page in Hindi.
উনি তো তাই বললেন যে আমার বাবা ইংরেজিতে হিন্দিতে সই করতেন, আমি তো তাই বললাম স্যার.
Please, please. No, sir. She has just said আচ্ছা কি গেছে একবার বলতে?
কি একবার গেছে
At
বলুন?
the bottom of the first page of exhibit A, there is
never
a
used to sign
signature,
it.
but this is not the signature of my father, as he used to sign in Hindi.
পারফেক্ট
পারফেক্ট
Yes.
স্যার আমি ঠিকই বলেছি স্যার
Signature, please, আরেকবার answer.
Yeah,
আরেকবার
at
পড়ছি
the bottom of the first page of exhibit A, there is a signature, but this is not the
No,
signature.
signature of my father. That is what.
No, 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 no.
That is what she said.
No, signature of,
My father, but he used to sign in Hindi. That is what she said.
সে কথা তো বলেন।
Otherwise, I would not have
কি
studied.
আপনি একবার পড়ুন আনসারটা।
At the bottom of the first page of exhibit A, there is a signature, but this is not the signature of my father.
in any case she does
No.
not, since she does not understand English, let us put the question to her once more
That is what we
with
have
an
heard.
interpretation in
And
Hindi.
perhaps your lordship has also heard it.
she found the signature at the bottom, but she said that this is not the signature of
No,
her.
that is not he said. I find the signature in the bottom
Yes,
of my father, but he used to sign in Hindi,
of my father is not recorded.
not recorded.
না সেটা বলে, it is not said. It is not said.
Let us put her
That
Let her put her the
Acha,
question.
just put her a question. The signature which you saw in the bottom of the page, according to you, whose signature it is?
Yes.
Please record this.
It cannot be said.
No, this is court is putting the question. Court is putting the question.
टू कोट इस पन्ने के अंत में आपको जो सिग्नेचर दिखाई दे रहा है, आपके मुताबिक ये सिग्नेचर किसका है?
ये पिताजी का नहीं है, वो हिंदी में करते थे।
This is not the
record that.
signature of my father, as my father used to sign in Hindi.
Okay.
Got your answer.
Madam, can you produce any document from which you can show your father's signature?
क्या आप कोई डॉक्यूमेंट पेस्ट कर सकते हैं जिसमें आपके पिताजी का कोई दस्तखत है?
हाँ,
Yes, I can produce.
Have you brought it with you?
क्या ऐसा कोई डॉक्यूमेंट आप अपने साथ लाई है आज?
हाँ लाई हूँ।
Yes, I have brought a document bearing the signature of my father.
Kindly produce the document.
No, how she can produce in this way?
Document
This is
The witness, my lord.
no. You see, these documents were disclosed earlier. These documents were not
My
disclosed.
lord, it is the responsibility to disclose the document at the time of discovery
No.
by
you
the
not-
defendant, by the party. But
No, at this
defendant,
all at a sudden you cannot take it by surprise in this way. It's better, you better give an inspection thereafter.
inspection for witness, there is no such provision,
No,
my lord.
question is you cannot take.
Witness for inspection of the document of the witness.
Any document relies.
I can
wants to
ask
rely, that
her
has to
from
be-
whose custody,
That has to be disclosed.
for whose custody you
Because
got
this is
this.
not in cross-examination. You see, had it been in cross-examination,
I
it would
could
have been.
produce.
But
That is
in
in
chief.
cross-examination of the party, but the witness is not a party.
Whatever it is, even
See-
parties are also witnesses. You see, when the
Parties
party
are
is in the
witnesses.
when the
but
party is in the box, he is a witness.
responsibility to produce the document and discovery is the responsibility of the parties of the suit.
Whatever
But
it is,
not
you
by-
see, the documents are relied by the parties. Okay. Now the question is, if you want to produce any documents to the witness, okay. Now that documents has to be given inspection. Otherwise, they will not know how they can cross-examine him.
I may not ask for inspection, but it has to be disclosed first.
It
After-
was not disclosed. Why that it was in the possession of the witness,
So let
not in the
that be
possession of the
disclosed.
defendant.
It cannot be.
Who will disclose it?
Okay,
The
let it
witness cannot come for disclosure.
Okay. Let it be disclosed. Thereafter, you.
Thereafter, yes. কোনো অসুবিধা কি?
Well,
Discuss করো।
In order 13 of the Civil Code of Civil Procedure, there is no such provision which it is to be followed up in chapter 13, chapter 14. of the high original site rules.
Yes, let us
Let my learned friend place the provision how to produce the document if it is from the custody of the witness.
No, did you
Kindly, my learned
when
friend.
you summon a witness to produce a document, that is one thing, okay?
That
Suppose-
is a different.
But
That
here,
is summoning.
here
the
you are
witness.
producing, here you are summoning your own witness with a document which is unknown.
He has brought, my lord. The witness is under my control, so summon is not required. Your lordship, which is talking about, that is for the witness who is the custodian of a particular document, but not my under
Anyway,
my
that
control.
has to be disclosed.
That
You
is
see-
that is different.
You see, all
That
whether
is
it is
after filing written statement. If the discovery comes, it is a
anyway,
responsibility.
then you satisfy
and-
me on the next occasion. Today, for today, you don't put the documents. Apart from that, you examine her.
The document is required, my lord. That is
Satisfy on the next day.
Your lordship, kindly take the document in record as the evidence with objection of my learned friend. With objection of my learned friend,
It is a
then I
defendant
will
who has come
clarify
before
it
the
at the
court,
time of
before the
argument.
witness box.
If it is not an admissible
Defendant-
document,
Witness, defendant's witness.
Defendant witness is in the box. So therefore,
defendant witness in the
if
box
the
and the
defendant wants to
document, I think
ভাই,
that he
একসঙ্গে
has
দুজনে বললে কথা হয় না একটু
আমাকে
দাঁড়াও
বলে নিতে
না,
দাও,
দাঁড়াও
তুমি তো মাঝখানে interfere করছো।
defendant is one of the parties to the suit. If the defendant or the plaintiff, whoever he may be, they want to rely on any document at the time of trial, well, that document they can.
Because it is the defendant who has
My
gathered
lord,
knowledge.
it is not an ordinary suit. It is a testamentary suit, and the defendant caveator has become the defendant in the suit. The provision is different. Provision is different. While something is to be proved or disproved, and it in the possession of
Anyway,
the witness.
you satisfy on the next
Satisfy
day.
and
Let
then-
your learned friend come ready with this on the points of law. So if you want to continue at 2 p.m. with regard to other examination, I will not conclude it because I will grant you
No,
opportunity.
that is to be continued.
Not today.
Not today. We can come back tomorrow.
Okay.
Tomorrow at 12. Tomorrow on points of law, my lord, my learned friend has to place the
I need
bar.
not place anything. First to
Provision of
satisfy
the
the
bar.
court that whether a document can be brought from the pocket and can be tendered.
If it is from the custody of the witness,
I know the
and
law,
not
my
known,
court also knows
not
the law.
known by the defendant or the plaintiff, it can be. It can be.
Yes, record and order.
The defendant is coming to give evidence, the defendant is getting a document without disclosure. And there is no such
She is
bar.
not the defendant witness anyway.
Anyway, same.
Defendant can also be a witness.
He's a
Defendant can
non-party
be a
witness. my lord.
Defendant,
This
any
is
witness
in
is
a caveat.
to be treated as a
Learned
defendant.
advocates for the parties.
Testamentary suit is a non-party witness.
Learned advocates for the parties are present.
Non-party witness.
Yes, he's not a party witness.
This is DW. No. This is OPW.
This is not OPW, this is a DW1.
Yes, DW1 is present in court. DW1 is examined in part and discharged. Point of objection is raised by learned advocate for the petitioner that this witness who gave the consent to the probate applications has come to depose, and this cannot be permitted. Learned advocate also draws attention to the order passed by this court dated 24/8/2017, where this court refused permission to file caveat on the ground that consent to the probate proceedings are filed. Stop. These objections of the defendant, petitioner's counsel is taken into consideration, and the defendant DW1 is provisionally permitted to depose in this matter, and this point of the right of DW1 to depose is kept open. Fix এই কালকে দেখুন তো আছে কিনা 12:30টার সময় কোনো ম্যাটার ফিক্স বা সাড়ে বারোটা ফিক্স নেই আর দুটোর সময় ওকে লেট দিস ম্যাটার অ্যাপিয়ার টুমরো at 2 p.m.
2 p.m.
My lord, may I take back that list of dates?
Yes, please take back.
ডাকে জানেন
ইমিডিয়েটলি ফিক্সড আছে ওটা ডেকে দাও।
My lord, with the leave of your lordship, kindly
Yes.
indulgence for the item 11, the next matter.
In this matter, my lord, I am appearing on behalf of the petitioner. It's my application, your lordship,
Lord, your
for
lordship
addition
has
of parties, your
directed
lordship.
plaintiff to appear. Lord, I was humbly praying I appear for the plaintiff. May I file opposition to my learned friend's application?
Yes, item 11, record and order.
But I appear for the joint receiver.
For the dependent number 1 and 2, my lord, led by Mr.
You are appearing for the first time.
No, my lord.
Earlier you appeared.
Earlier appeared, your lordship.
Yes, learned
Okay.
advocate for the parties are present. Learned advocate for the plaintiff prays for time to file affidavit in opposition to GA 15 of 2025.
Yeah.
Such prayer is allowed. Let affidavit in opposition be filed by
Lord, very old suit, 40 years old. My lord, kindly allow me 3 weeks subject to my lord.
The application is, your lordship, is a simple application for adding of parties, your lordship. I do not have any claim neither against the plaintiff nor against the defendants, your lordship.
Okay,
My
by
claim is strictly against
7
the joint
2025,
receivers, your lordship.
3rd of July.
3rd July, your lordship.
Affidavit in opposition.
Lordship.
Reply if any.
Lordship.
Reply if any by 7/7/2025.
Lordship.
7th of July.
7th of July, your lordship.
Let this matter appear on 9/7/2025.
9/7/2025. I'm grateful to your lordship.
Under the heading adjourn motion.
My lord,
Grateful
may
to
it
your
appear along with several other.
No, let this matter be decided first.
Lordship. Lordship. I'm grateful to your lordship.
Much obliged.
Yes, call the 2 p.m. matter.
For arguments, item number 38 fixed at 2 p.m.
Bring.
Well, on 19th of May, my lord was pleased to pass an order.
Just a minute. This is item 36. No, 30. 38, right. Let me see the order.
No, get out. এটা সরিয়ে নেবেন না এটা ওদিকে স্যার অর্ডার শিটটা
Yes, let me see the order. Yes, on the last occasion, I granted you opportunity with regard to the admissibility of the document, whether you are recording, whether you are willing to cure the defect or not.
My lord.
That is why I adjourned the matter.
My lord.
Anyway,
My lord.
so I granted you opportunity to take instructions.
My lord, we have taken instruction, my lord. I just wish to draw your lordship's attention to two provision.
Yes.
If your lordship kindly takes the stamp pack, খুলে দাও দাগ দেয়া বই কোথা থেকে এনেছো এসব?
Yes, I have one.
My lord.
Section.
If I may just trouble your lordship with one section 33.
33, yes.
My lord, I am restricting my submissions to the court's power to impound.
My lord, with utmost respect, my lord, that is not the issue. Issue is they have to tell this court whether they want to impound the document, yes or no.
Whether they want to cure the defect or not.
Correct.
If they don't want to cure, the consequences will follow. At the hearing, they'll make their submissions.
So, For
So,
the
end
purpose
the
of
story. So
curing, I am
please,
showing this
yes,
provision.
Yes and no. If they take the chance, let them take the chance.
Possibly, my lord, subject, if I place the sections, your lordship will be,
Yes,
it
section
will
33.
become evident whether it is not a situation of yes or no. If your lordship will kindly take 33, every person having by law or consent of parties authority to receive evidence.
Yes.
But pausing here for a moment, so your lordship sitting in the ordinary original civil jurisdiction has the authority to receive evidence. And every person in charge of a public office, except for police, except an officer of police, before whom an instrument chargeable in his opinion with duty is produced or comes in the performance of his functions, shall, if it appears to him that such instrument is not duly stamped, impound the same. So, my lord, here is your lordship's authority to impound. Now, my lord, kindly take page. My lord, kindly take section 38. So, once your lordship exercises your lordship's authority under 33 to impound, my lord, my respectful submission, my lord, 38 comes into play.
Yes.
So, 38 says, where the person impounding an instrument under section 33 has by law or consent of the parties authority to receive evidence and admits such instrument in evidence upon payment of a penalty as provided by section 35 or of the duty as provided under 37, he shall send to the collector an authenticated copy of such instrument together with a certificate in writing stating the amount of duty and penalty levied in respect thereof, and shall send such amount to the collector or to such person as he may appoint in this behalf. Well, subsection 2 says, in every other case. So, well, what is not covered under subsection 2, 1 is covered in subsection 2. So, well, in my respectful submission, my lord, your lordship has the sufficient authority to impound under 33, which your lordship will do in this case, which is the instrument which is exhibit Q marked with objection. And my lord, exercise your lordship's authority under 38, because which is the procedure prescribed under the Stamp Act. My lord, because here I'll tell your lordship why. If your lordship takes exhibit Q, there is no stamp on this document. So, my lord, the authenticated copy has to be sent.
Understanding.
Correct. Which is the agreement for sale, of which I seek specific performance. So, which your lordship needs to say that this is the authenticated copy which will be sent to the collector. So, the collector will take steps.
Can suo motu do or by application of the parties, right?
No, my lord, if your lordship
By
will see suo motu, your lordship can under 33.
Yes.
Your lordship has the power as a court to receive evidence when your lordship is of the view that the instrument is not duly stamped. That is the only conclusive finding your lordship has to come to, that this instrument deals with transfer of an immovable property in excess of the value of rupees 100. So, stamp is required under the Indian Stamp Act, Schedule 1A. Accordingly, it is impounded and sent to the collector under 38. And no stamp is paid. So, the authenticated amount, like, my lord, as in by way of a illustration, if it usually your lordship will see agreement of sale around 100 rupees or 50 rupees, then, my lord, the court which is impounding, in my respectful submission, is required to indicate that the instrument, this is the authenticated copy, and the instrument 100 rupee stamp has been paid, and accordingly it is sent, and the collector does whatever is required under the Stamp Act. Now, these are my limited submissions. Your lordship will exercise your lordship authority under 38, impound it and send it to the collector, and thereafter the collector will assess.
Obtain the collector's report.
Yes, the collector will do the needful. Now, if your lordship will kindly see, my lord, once this is regularized, my lord, if your lordship will take 41s,
yes,
it has to come back before your lordship once regularized. My lord, first situation is when the collector impounds it under 38. This is not the situation. My lord, kindly see, when the collector impounds any instrument under 33, which is not the situation, it is the second situation, or receives an instrument sent to him under section 38, which is our case. Your lordship will send it under 38 to the collector. Then what is he supposed to do? under subsection 2 not been an instrument chargeable with stamp duty only or a bill or exchange or such and such. If he is of the opinion that since we are duly stamped, then he'll exercise that. And towards the end, your lordship will see subsection 3.
Yes.
Where an instrument has been sent to the collector under section 38 and subsection 2, the collector shall, when he has dealt with it as provided by this section, return it to the impounding officer. So this is all that I was respectfully submitting before your lordship.
So let me
Exhibit
hear the
U.
matter, thereafter pass the order.
My lord.
First hear the arguments.
Well, your lordship can impound it, so the argument cannot pursue anymore, because if your lordship impounds it, now if I am able to or unable to cure the defect as per the collectors, then consequences will follow. That Mr.
Will
Of course. Then Mr. What Mr. Shortkar said was absolutely correct. So then the situation will be entirely different. So that once the instrument is impounded and sent to the collector, so then, my lord, the court has to await the report of the collector. Absolutely. So that exercise may be undertaken. Should have been undertaken long time back, but anyway. But the matter is still pending.
Let me pass an order.
My lord.
Lordship, one portion of proviso of section 33 may I point out.
Yes.
Provided that, Lordship got it? Sorry.
Yes.
Provided
yes.
that skip A, B. In the case of a high court, judge of a high court, the duty of examining and impounding an instrument under this section may be delegated to such officer as the court appoints in this behalf. So, Lordship can impound can he appoint a collector to impound the document and send it back to court.
Impound, assess and then send back.
Lordship.
No, my lord, subject to correction if your lordship reads.
No, first is impounding by the court.
Impounding, and then your lordship will exercise powers under 38 and send it.
Yes.
The authenticated copy. Then he will undertake the exercise under 39, 40 and send it back to your lordship.
In fact, the duty of examining and impounding may be delegated to such officer. It's very clear, my lord. Your lordship need not do that exercise.
No, my lord, if your lordship will see.
Judge has been kept above that. Calculating.
No, calculation is not with the High Court.
The court has to give it to send it to the
registrar. No, I'll tell your lordship, if your lordship will see.
It is the court's power to impound. There are many orders. Okay.
Of course,
absolutely.
Many orders passed by this court in the original side.
Impound and send it to the collector. It is beyond Calcutta High Court or the High Court judge or even the district judge. It is not within his jurisdiction. He will impound. Impounding is within his jurisdiction.
Assessment and refer it to the collector for assessment.
He will regularize the instrument if the party on who is entitled or liable to make payment of the stamp duty, if he fails, whether it is the penalty amount.
It can be done after sending the matter to the collector.
Yes.
Parties may be directed to appear before the collector with regard to the.
Yeah.
So that the matter
I
is
have to appear.
expedited.
I have to appear.
Otherwise, if I wait for the report and then direct the parties and all.
Absolutely. But this was.
How many months it will take, we don't know.
Correct. This was my next submission, your lordship. It has already fallen from your lordship, so I need not make that.
To appear
absolutely. Well, parties no. I have done. He doesn't have any right. I have a right because I have to pay the stamp duty. It is between me and the collector. So if your lordship will see, and my lord, these 33, there is a West Bengal amendment to section 33.
Yes.
So
33.
Yeah, 33, there's an amendment.
Anyway, it is not reflected here in this book.
No, my lord, the West Bengal amendment is there to section 33. After subsection 1.
Yes.
Subsection 4.
Correct.
After subsection 1.
No, if your lordship will see, 33, if your lordship will see, please renumber existing matter of the original subsection 1 as A. Of subsection 1 and after A, please insert the following clause. So, my lord, B, what Mr. Shortcut just read out, my learned friend, possibly is not a part of the West Bengal amendment. So, subsection 2, 3, my lord, they don't form a part of.
So, B.
Yes. Be that as it may, my lord, that may not be relevant at this stage. What I was respectfully submitting is that lordship will impound and exercise your lordship's power under 38 and send it to the collector. And the collector will do the needful.
The
Yes,
plaintiff to appear before the collector.
Right, right, right. And my lord, only a time frame. Otherwise, my lord, it will become indefinite.
Yes, record an order.
Well, this will be without prejudice to my rights and contentions, of course.
No, this is confined to only one document.
No, but they are impounding at such late stage without prejudice
Because
to my rights and
it is also
contentions.
duty of the court.
Of course,
to
I'm
impound
not
it.
standing in the impounding, my lord. All I say, this they are doing after so many years, this is without prejudice to my rights and contentions, because I might take some legal point on this.
Yes. Mr. Bose, learned advocate for the plaintiff, and Mr. Sharkar, learned advocate for the defendant, are present. Dujani senior advocate, are learned advocates. Upon hearing the learned advocates, it is brought to the notice of the court that the memorandum of understanding, which is marked exhibit,
This is memorandum of understanding
entered into between the parties
subject to objection.
Entered into between the parties on which date? Do you know?
Yes, yes. The date I'll tell you, lordship. Kindly give me a memorandum of agreement dated
20 January 2000.
28th of January 2005.
28th of January.
8 January 2005.
2005. Stop.
Exhibit
It is submitted by the. It is submitted by learned advocate for the. The said document is marked exhibit
Q subject to objection.
Subject to objection. Stop. It is submitted by learned advocates that learned advocate for the defendant that the document is not stamped and therefore it is inadmissible in evidence. Stop. Upon hearing the learned advocates and considering Section 33 of the Indian Stamp Act 1899, this court is of the view that the said document should be impounded. Thus, in exercise of the power conferred under Section 33(1) of the Indian Stamp Act 1899, this court impounds the memorandum of understanding dated 28th January 2005, marked Exhibit U to the marked Exhibit U.
Q, my lord.
U for university.
No, Q for quality.
Q.
Logically mentioned subject to objection.
Q subject to objection, which was raised by the party. This memorandum of understanding, it appears, is an agreement for sale which the plaintiff seeks to enforce in this particular suit. Stop. Thus, this court is of the view that the plaintiff is under an obligation to pay the stamp duty after being assessed by the collector under Section 39
and 40.
39 and 40 of the Indian Stamp Act 1899.
Right.
Stop. Let this document be sent to the collector by the registrar original site for assessment of the stamp duty and for compliance of the same by the plaintiff. Stop.
Well,
The plaintiff is directed to appear before the
examining and impounding. The language of the section is examining and impounding.
No. Yes. No. I have recorded that as per Section 33 of the Indian
Correct.
The plaintiff is directed to appear before the collector on the date fixed by him, and
collector will give hearing to both the parties.
And the plaintiff and the defendant shall appear before the collector on the
The
date.
defendant, your lordship, this will
See,
become
a particular case, in a particular case,
Yes.
a dispute is pending before the division bench. There was a direction by the division bench that the parties will share the stamp duties equally. It went up to the apex court, and thereafter it
They're willing to share the stamp duty, then I have no objection. Then they can appear. If he doesn't, I'll tell
that
you.
dispute went up to the apex court. It is hearing is still pending.
So,
And I
my lord,
am
what,
part of that.
so
bench.
I can understand that, my lord. If he will not share it,
Anyway, let him appear. Just the party.
so, my lord,
shall
I'll tell your
appear,
lordship what will happen. This will become an adversarial litigation before the
but
collector.
don't take adjournment, okay?
That's why I'm saying it is not required for them.
None of the parties
It
will
is
take
even I cannot appear. All I can do is that collector will assess, intimate me, this is the amount, I will have to pay the amount. So here with the defendant comes in,
Not act to your prejudice.
in a adversarial litigation, defendant's ultimate objective is to act to the prejudice of the plaintiff. Because naturally this instrument is the subject matter of the principal
Anyway, you will not
agreement.
appear, your junior will appear.
Nobody might appear even, that's besides the issue, but it should be a fair.
No, my lord, I am saying, my lord, the 33 or 38 does not contemplate a person who is otherwise not entitled to pay the stamp duty, liable to pay, can appear.
Collector may hear the parties
Yes.
before arriving at a decision.
Correct.
Such steps shall be taken within a period of 4 weeks.
And my lord, kindly say, and to do whatever is required and send back the instrument within a
The
period of.
collector shall take necessary steps and assess the stamp duty within a period of 4 weeks from the date of communication of the order.
So 4 weeks se korte parbe na.
Yes, we appear and expedite the matter.
Absolutely, absolutely. We'll do that. We'll do that. We'll do that.
Garnet advocates are requested to see that the matter is expedited.
Absolutely, absolutely.
Let this matter appear on 23.
Very well.
23rd July 2025.
Well, instead of 23rd, would it be a lordship pleasure to keep it on the 24th?
Okay,
Yes,
24/7/2025 at 3 p.m. Shall I make it a part-heard matter?
Of course, my lord.
I think you already has. On the last order, it records it's a part.
It should be
It is a part. It is recorded in your lordship.
Let him mention the list also as part.
It is mentioned already.
Yeah, 3 p.m.
Wait, one minute.
Adjourn motion.
One sentence subject to your lordship, register original site and all parties to act on the server copy of the order.
Yes,
So
all
there is-
parties are directed to
Including the
all parties are
registrar.
directed, all parties, including the collector
And
shall-
registrar.
and the registrar original site shall act on the
Server copy.
copy of this order.
Yes. Deeply obliged. ma'am.
Adjourn motion, item number 12.
My lord, this is my application, my lord. On the last occasion, my lord, Mr. Banerjee appeared as my senior.
Yes, I'm appearing online, my lord. My camera is not working properly. Lordship, this is a application for judgment upon admission for passing preliminary degree in a partition suit. All the parties have agreed to that, to the share percentage. All have agreed to the share percentage, my lord. The only thing is a formal order has to be passed by your lordship. If your lordship kindly takes up GA6. If your lordship kindly takes up GA6.
GA7, right? GA7.
GA6 and GA7, two applications are there, lordship.
GS7, please.
If my lord kindly consider part 1 and part 2 of annexure A and annexure B, my lord, of the plaint, my lord.
Annexure?
Page 6, first prayer, my lord, of GA7.
6.
My lord, page 6 of GA7.
Yes.
My lord may.
So parties, after the shares are declared, parties are not ready to amicable to partition by amicably. So a commissioner has to be appointed.
My lord, kindly consider page 19 of the GS7, my lord. From there, my lord will find the share of the plaintiff. That is 1 by 16.
19.
No, page 19 of GS7, my lord.
Page 19. Yes.
My lord, find, my lord, plaintiff dot 1/4 into 1/4, that is 1 by 16. That is my share. There is no dispute. Now, my lord, kindly come to their written statement, my lord, page 38. Page 38, page 4. That is the written statement. I have already annexed here, my lord.
30 page.
38.
38.
38. 38. Running page 4, my lord. Internal page 4.
Yes.
My lord, the bottom of the first paragraph, my lord. Only heirs, and accordingly they have also inherited 1 by 16 share. Srimati Tapodash and plaintiff has not disclosed the facts by the. So 1 by 16.
No, paragraph 9 you are reading.
9, no, 8. 8 bottom. 8.
No, running page 4.
Running page 4. Just
paragraph 8 bottom.
Bottom, my lord.
Yes. So defendant number 9 died during pendency of the suit.
Defendant number 9 has died. I am representing 10, 11, and 12, my lord. I am agreeable, my lord, to my lord, the preliminary decree, my lord. And in terms of, my lord, the share which is, my lord, at page 19, my lord, which my lord has just showed, which is 1/12, 1/12, and 1/12, my lord. There is no disagreement between me and the plaintiff.
And my lord will kindly consider page 10. Page 10, my lord, that is 44. Internal page 10.
Yes.
Para 14. With
Yes.
reference to paragraph 9 of the defendant deny and dispute sum, the allegations of the plaintiff is being deprived of enjoying in share joint property and deprived from enjoying income thereupon. There is no apprehension that suit of properties and such. There is no income. Blah blah blah. The defendant are ready to partition the property of accordance with 1 by 16th. They admitted, my lord. They admitted my plaintiff, being a plaintiff, I have already stated 1 by 16. So far as 1 by 16 is considered, there is no dispute by the parties, my lord.
I believe, my lord, the plaintiff and 10, 11, 12 are add item, my lord.
You are appearing for?
She is appearing for 1 to 8.
Appearing for my landed senior, my lord, my Madan Mohan Roy, my lord. We have to leave the court, my lord, for personal difficulty.
You have filed your written statement.
Yes, it's annex, my lord.
Oh.
It is annex.
These are on record.
I am praying for. He have to leave, my lord, for personal difficulty, my lord.
Lordship, kindly see how many times.
No, they have filed written statement.
Yes.
Annexed.
That is annexed. Lordship, parties are agreed to something.
As per the written statement.
As per the written statement.
No, even before your lordship, when we stood, we said before your lordship. Last 3 days he was present, today he is not. So my court's time or my fate do.
Okay, you take instruction. I am keeping it tomorrow at 4 p.m.
Lordship, instruction is lordship. In a written statement, everyone said.
Day after tomorrow at the top of the list.
No, করা দরকার নেই, তার থেকে 4টে হয়। আপনি তো শুধু instruction নেবেন যে।
No, day after tomorrow it is difficulty. On Friday, second half there will be appellate set probably.
Yes, 11 a.m. lordship.
Always uncertain, my lord.
Friday.
Friday.
10:30, 11, whichever suits your lordship. I'm available, but then 10:30 they might not be able to reach and all. So 11:30 or 1 p.m. is the safest lordship because it takes 2 minutes of your lordship time. 1 p.m. We will all come and say, yes, it is admitted.
Okay, or Friday at
1 p.m. or 2 p.m. whichever. Lord, 1 p.m. is
whether,
good.
I don't know whether at 12:30 there will be division bench or not on Friday. So there is some uncertainty. So yes, 10:30 you have any difficulty?
11:30 করে দিন।
Yes, ma'am.
10:30.
10:30, no.
Or 11, I am keeping it at 11.
11.
learned advocate for the plaintiff and learned advocate for, yes, you are representing
10, 11, and 12.
10, 11, 12. You are representing?
Plaintiff.
Who was representing virtually?
He is for 1, 2.
No, no, virtually.
I was there virtually, Lordship.
Okay.
My camera was not working, so I rushed.
Learned advocate for the plaintiff, learned advocate for the defendant number 2, 3. Yes, you are?
8, 9.
8,
10,
9?
11, 12.
8, 9, 11.
No, 10, 11, 12.
10, 11, 12 are present. Yes, you are representing which defendant?
8, my lord.
And learned advocate for defendant number 1 to 8 are present on the prayer of learned advocate for defendant number 1 to 8. The matter stands adjourned till 20th June 2025 at 11 a.m. as the last chance. Yes, at 11 a.m. it will be
Lordship,
taken.
I will be present. I'm deeply
obliged.
Item number 13.
For the defendant for 1A and 1B matter, my lord. GA5 is our application praying for leave to file the written statement at a related stage. My lord, in this application, the plaintiffs have filed
For the defendant.
Yes, I am for the defendant number 1A.
This for? This application is for?
Application for leave to file our written statement because we were substituted at a very later stage, and by this time sufficient time has passed. The suit is of 2011.
They have filed their opposition.
They have filed their opposition. We could not file it. You are granted 2 days time, but in the meantime we could not prepare. I'm praying for only 7 days time to grant time to file our written affidavit in reply to this application. And the date may be fixed for hearing, my lord.
Yes. Yes, record and
That's my opposition.
learned advocate for the plaintiff and learned advocate for the defendant are present. Let the affidavit in opposition filed by the plaintiff opposite party be kept with the record. Copy be served.
Copy served.
Copy served.
Learned advocate for the defendant petitioner prays for time to file the affidavit in reply. Such prayer is allowed. Let this matter appear on. Affidavit in reply may be filed within by 1 week.
1 week.
1 week. And copy be served. Let this matter appear on 30th June 2025.
Grateful, my lord.
Item number 14.
Lordship, item number 14, I was directed to file my affidavit in reply by Monday. There has been a bereavement in the client's family, my lords. I am for the appellants. I was praying for a fortnight's time because they are.
GA6 is your application.
GA6 is my application to be added a party in the suit, my lords. They have filed their opposition. I was supposed to file a reply by Monday. There's been a bereavement in the client's family.
1 to 5, your lordship.
Yes.
And for the defendant numbers 1 to 5.
The bereavement in their family.
You are for defendant number?
I am for the applicant in GA6, my lords.
Oh, intervening.
Has made an
Intervene.
application for intervention,
They
your
intervene.
lordship, in a suit.
Yes, record and order. Learned advocate for the applicant intervener and learned advocate for defendant number 5.
1 to 5.
1 to 5 are present. Learned advocate for the applicant intervener prays for time to file affidavit in reply. Such prayer is allowed. Let affidavit in reply be filed by 26.
It gives me a fortnight. They are traveling because of a bereavement. Not sure whether they'll be back anytime
Okay,
in July.
3rd July
I'm so
2025.
grateful.
Let this matter appear on 7/7/2025.
I'm grateful, madam. I'm grateful.
Deeply obliged.
For hearing, item number 15 with item number 16.
Lordship, I appear on behalf of the plaintiff respondent pursuant to your lordship's order dated 14th of May 2025. We were to file our affidavit in opposition. Lordship, we filed it and we served it on 11th of June. We were a day late. Lordship, may I file the affidavit in opposition?
Yes.
I'm humbly praying for some time to file the reply there to my lord.
GA9 is whose application? Your?
His petition.
Lordship, the petitioners, the
It's the
defendant
exception my lord, in essence, this is an exception to the commissioner's report. We have given the
You are
reason.
representing?
I'm for the plaintiff respondent. Lordship, this is for adjudication of the mean profits.
Okay.
Mean profits without a decree, my lord. So
Yes, record and order.
may pray for 3 weeks, my lord.
Learned
weeks because, my
advocate
lord.
for the parties are present. Mr. Bagh, learned advocate for the defendant petitioner, prays for time to file affidavit in reply. Affidavit in reply.
In reply, my lord.
The prayer is allowed. How soon can you file?
You know, 3-4 weeks, my lord, because they have to go, my lord, it's a government entity, and we have to, my lord, send it and get it. Send it to Dhanbad
Let
and then, my lord.
affidavit in reply be filed on or before 10/7, 10th
very
of
deep,
July,
my lord.
10/7/2025. Let this matter appear on 14/7/2025.
Deeply, my lord.
Lordship, affidavit in opposition to be kept with the record.
Let the affidavit in opposition file be kept with the record.
Grateful.
Deeply, my lord.
Testamentary matters, item number 17.
Yes, not today.
Item number 18.
Not today.
Old suits, item number 19.
Appear for the defendant.
Yes.
What is it for? For hearing your witness.
Yes, Mr. Ghosh, you are appearing for
Well,
the.
I am for the defendant. The written statement had been amended.
My lord, in this matter, may I file my brief of additional documents? It has been served upon us.
Issues are not yet framed.
Issues framed, their evidence had also even begun.
Yes.
1982 suit.
Yes, yes.
But new documents were disclosed. Inspection, I'm told, is not complete.
She didn't turn up.
Hmm?
Your solicitor did not turn up.
That's between you and him.
So affidavit of new documents.
Yes. Leave was given and both sides have disclosed new documents. Let there be some time for us to complete the inspection. And then my
Waited
learned
for
friend-
40 years, you wait for few months.
I'm the defendant.
No, you have the plaintiff has waited for.
No, his witness went in 1990. And thereafter they took no steps.
Advocate on record wanted inspection. On
Because this matter is also appearing, parties are not appearing. Matter was appearing
No,
in the
this
list.
matter that has been, my learned friend's been appearing. We are waiting for him not to appear, then we'll have it dismissed.
Yes, record and order.
My lord, may I file my brief of
Yes,
additional
yes,
documents?
Well, good.
Learned advocates for the parties are present.
Yeah, we've given.
Learned
He didn't turn up.
advocate for the plaintiff
Yeah.
files affidavit of new documents. Let it be kept with the record. Yes, Mr. Ghosh, copies have been served.
Yes,
My
copies
lord,
have been
Mr. Dutt
served.
is appearing.
Yes.
Inspection.
So you are
secured.
filing affidavit of new documents.
Judge's brief of documents. The new supplementary judge's brief has
Yes.
been filed by them.
Affidavit, supplementary affidavit of the judge's brief of documents.
Well, it's in not in the affidavit, but it's in the form of
Judge's brief.
judge's brief.
Supplementary judge's brief.
Okay. The plaintiff files supplementary judge's brief of documents.
It has been served on us now.
Copy served. Let it be kept with the record.
Inspection
Let
is
the
not completed.
let the inspection discovery and let the inspection be completed.
Let quoted.
Let the inspection be completed on or before 1st July 2025.
1st July, perhaps too early, my lord. 15th
Okay,
July. 15th July, my lord. If it comes, then he is to recall his witness or I don't know, new witness. What will happen after that?
No, after, yes. So let it be completed on or before 15th July 2025.
25.
And Millard, we had some additional issues.
Issues can be recast at any point of time.
It can be, but
so we will come back with our suggested issues.
Yes. Because at any point of time, issues can be recast. So come on
So
the
your
next
lordship
day.
record, my learned friend has
Okay.
given a suggested additional
Learned
suggested
advocate
issues.
for the plaintiff
We'll
file
bring
suggested issues.
additional
Suggested issues. Let the same be kept with the record and taken up for consideration on the next date fixed.
And we will file our suggested issues, if any, addition.
The learned advocate for the defendant may also file the suggested issues on or before the next date. Let this matter appear for further evidence of PW1. Further evidence of PW, plaintiff witness, on 22nd July.
Let it come for the framing of issues on that day, and then your lordship.
Then we'll prepones the date for fixing the issue and then 22nd.
Let this matter, no,
Because it will take
you got to complete it before 15th.
Yes,
On or
15th, the
before
inspection
15th.
is 15th. 22nd, your lordship is keeping it. Your lordship will finalize the issues.
No, when shall I keep
And
it?
then
Maybe
their evidence
before
when they-
22nd.
For fixing the issues so that on 22nd we can come back
Fix
with the evidence.
22nd July 2025
Yes.
for consideration of the issues.
Yes.
Consideration and framing of issues.
Additionally, great.
Consideration and framing of additional issues.
inspection की 22 तारीख को रखा।
Great.
Yes, 22nd, and prior to that, prior to 15th, you have to
Yes,
complete
they
that. 22 তারিখে for additional issues. আচ্ছা, 3টের সময় ফিক্স ম্যাটার একটা উইটনেস 3 PM ফিক্স ম্যাটার বলে দিন তাহলে।
Witness action, item number 39, fixed at 3 p.m.
But I appeared for the defendant. But I had started my examination in cross-examination yesterday. When they had concluded, 2 questions I had put. But when we had sat with the matter, we saw that depositions for last 2-3 days have not been obtained. And also the judge's brief is not there. I have asked my advocate on record to write to the other side and obtain all this. And also Mrs. Noel Banerjee is there. He has some
she has
had a
not-
bereavement and there's
Yes,
some.
I'm appearing for the.
So,
So there's a
we had a discussion yesterday and we had jointly we'll be jointly praying for an accommodation for this week.
Mrs. Banerjee will come from next week probably.
Yes, or maybe from tomorrow. But if it could be there next week or any other day, subject to my lord's
Yes,
convenience.
record an order. Learned advocates for the parties are present. On the prayer of learned advocates, the matter stands adjourned till 30th June.
I'm
30.
just seeking 2 weeks adjournment. ma'am.
2nd of July is 2 weeks.
2nd of July is at 3 p.m.
It's দেখুন তো
Whenever your lordships.
Second of July 2 PM এ কি arguments না witness?
3 p.m. then, Miller.
Okay, 2nd of July at 3 PM.
Great.
Great.
I'm sorry. But could it be after the 8th, my lord, any day?
তাহলে 9 জুলাই করে দিন তো 9 জুলাই 9 জুলাই Okay, 9 July at 3 PM.
I'm so good.
All suits, item number 20,
It's not today.
21,
Yes, not today.
item number 22,
Yes, not today.
23,
Not today.
item number 24,
Yes, 24.
My lord, I'm for the petitioner defendant. My lord will recall, my lord, this my lord, appeal dismissed, no stay. Thereafter, they after 1.5 months they came and said we have filed a recalling application. Your lordship had only fixed
You are
it.
for the defendant.
I'm for the defendant decree holder in counterclaim. I got a decree of eviction. My lord, they had mentioned the matter. The matter was in the list. The Honorable Division Bench has not restored the appeal and has posted it in August. No stay. September. No stay. Kindly, my lord, today, my lord, allow me to proceed.
Regarding your matter, it is there, but plaintiff who is appearing?
But plaintiff every day they come
and they seek for time. My lord recalls before just 1 week before when they came, they said, now we have made an application for recalling of the order of dismissal of the appeal. It was placed before the division bench. Division bench has not restored the appeal and has posted it in September. So no stay today. Kindly execute the decree. There is no, today also they are not there.
No, plaintiff suit has failed.
Plaintiff suit has failed. My counterclaim as a defendant has been allowed for eviction.
Yes, yes. Now your counterclaim is allowed and plaintiff suit has failed.
Failed. Now from that decree, they have preferred an appeal.
Yes.
Appeal court passed an order. Passed an order saying that you put in 10 lakhs for stay. Not done.
Stay of the execution.
Stay of the decree. Stay of the decree.
Yes.
Now, my lord, they did not put that 10 lakhs. Thereafter, hearing was going on. Then the
Hearing of what?
of the appeal.
This court is to hear what now?
This court is to only hear my execution.
Execution case is fixed now.
This is for the mean profit application.
The execution.
Okay. Execution application.
My lord, your lordship is to appoint a referee.
You are appearing for?
I appear for the person who has suffered the decree.
Plaintiff.
Plaintiff.
So
Last chance, we are filing
Yes.
the opposition to their application.
your file?
And I believe it has been served.
No.
Service has been?
No.
It is ready, we'll file it by the course of this.
My lord, what is going on? This cannot be so casual, my lord. So casual. Nothing is served. Nothing is given.
This is the affidavit of opposition. I thought the adjournment record was not there. I'm serving it, I'm filing it here. Serve a copy of
No copy has been served on us.
I know that. Apologize to my learned senior friend. I will serve a copy by the course of this. That's an assurance.
File
from
your
my side.
reply by this week.
My lord,
File your reply by this week, by Friday. Or by Monday.
Monday, my lord, kindly give.
Yes, record an order. Learned advocate for the parties are present. Application, which is your GA? Which application is GA? Which GA?
This today that is appearing as item number 24.
Yes.
That is the GA. That is an application for mean profit.
Yes. What is the number? GA 19?
GA 18, I am told. my lord.
18.
And
GA 18
GA 18.
of 2024 is taken up for consideration as affidavit in opposition has been filed and copy served just now. The learned advocate for the plaintiff
I have
6 times.
given to my learned friend.
Yes, I've recorded. It is served just
Yes.
now. Learned advocate for the plaintiff 6 times to file the reply. Let affidavit in reply be filed by
My learned advocate for the defendant seeks to file reply. I am the defendant.
defendant.
Seeks to file reply.
Reply. Let affidavit in reply be filed by 24/6/2025. Let this matter appear on 30th June 2025.
But if your lordship is giving us, if it matter is returnable 30th, then some slightly more time may be given for reply. Your lordship is fixing it on 30th.
Okay,
So
okay. Then you file reply
by my lord 28th, my lord, if it commences, so that one day in advance I can give
27th June.
27th. my lord.
I was humbly beseeching one thing. I know my learned friend will oppose.
Let this matter appear on 30th.
30th, my lord. Yes, sir.
I was humbly beseeching one thing. I know they will oppose this. Appeal which I have filed was dismissed for default.
Yes.
I made an application before the division bench.
Yes.
Now the division bench is of the opinion that we have not deposited the money for stay. So I will not restore. I will hear the application in the month of September.
Yes.
So we are mentioning this matter before the division bench either tomorrow or on Monday. So I was humbly
See,
beseeching if your
whatever you
lordship
want
take,
to do, you are
takes this
getting.
about in the second week of July.
You see,
Well, let it
you
be
see,
30th.
I have kept it up to 30th.
Let him get
Whatever
it
order you can obtain either from the division bench or from the apex could be obtained.
I was
And
humbly
thereafter I
beseeching
shall
for 2
do
more
the
weeks.
needful.
That is
But
the
enough indulgence has
2
been
more
given.
weeks.
Let him get
Yes.
the order.
I was humbly beseeching for 2 more weeks.
My lord, if
So
he
that I
gets
can
the order,
persuade-
he can mention. I will not
Persuade
oppose.
the honorable division bench to restore the appeal
Let him
and
do
get it
that.
heard because
Let
we are
him-
not any
not in the financial position to deposit the money.
You get some interim order from the
Yes,
division bench.
that is what we'll
So
pray for.
mention that we will.
I am
obviously
saying that
we'll
the
get-
time limit is too short, only 6 weeks time.
Right,
There-
they should be more up and doing because of
You
that period.
see, now today is what? Today is 18th.
18th till
I have kept
30th.
it on 30th.
Kindly keep it after first week of July. I am not praying for 2 weeks.
No, what is the magic in that? I do not
No,
understand.
I might persuade the bench to hear out the
So
matter.
let
It
him-
will also might take some time. I
Okay,
will
I'm
make
keeping
some-
it out 3rd of
3rd
July.
July. Very
3rd, 3/7/2025.
My lord, great, your lord.
Item number 25,
Yes, not today,
26,
not today.
27,
27, I appeared for the plaintiff, but we had taken out an application for reconstruction. But because the records are not, but we have tried to serve them, but the envelopes have returned. And the envelopes have returned.
They have already amended their plaint. Address was changed, but now they are sending in the old address. How can it be served? They have
You are
amended the
representing,
plaint.
you are representing?
I'm for the defendant.
ওনাকে serve করে দাও না?
Given number 1. Home trust.
There is no wakalatnama. It is possibly not entered. They have not entered appearance. I do not know. Possibly.
How many defendants are there?
This is the amended application, this is the address.
But in the amended plaint, this is the address 40/1 Mahatma Gandhi Road. Same address.
This is the amended plaint.
You verify the amended plaint?
No, my lord.
Verify the address?
Yes, my lord. This is the Home Trust. At it is 40/1 Deshopriya Park East. It is by 5/3 Deshopriya Park East. They have amended like a hottest manner without with wrong address.
Oh, the amendment.
Name road name is correct. Premises name is different. This is their amended plaint.
In the amended plaint, it is 40/1 Deshopriya.
No. This is the trustees. এই তো amended plaint এটা সার্ভিস হয়েছে আমাকে।
হ্যাঁ, তো এখানে
এই যে 40/1 দেশপ্রিয় পার্ক ইস্ট
হ্যাঁ
কলকাতা।
তাই তো আছে।
তো 41 বাই দেশপ্রিয় পার্ক ইস্ট তো নয়।
নয়। ওটা
3/5, 5/3.
This is not reflected in the plaint. This address is not reflected in the plaint.
মানে address, the road name is correct. Premises number is wrong.
So leave be granted to rectify the cost title. Let me grant leave to rectify the cost title.
Only the address, instead of 40/1, it should be 5/3.
No, did you take out this application is for what?
For reconstruction, because the originals are not available.
So discovery inspection.
So discovery inspection, nothing. The suit is not being able to be proceeded with.
And so far as the name address of the trust is also correct.
Original.
ট্রাস্টিটা তো কারেক্ট করতে হবে। এটা তো টিসির এর ভিতরে সার্ভিস করা।
হ্যাঁ।
জানতাম না। জানি বলে
কি এখন কি হবে? দেশপ্রিয় একটা কথা থেকে গেল।
মহাত্মা গান্ধী রোডই তো আছে।
তুমি তো লিখেছো
মহাত্মা গান্ধী রোড কোথায়?
এটা তো দেশপ্রিয় পার্ক।
No, from where did you get this information that the address is changed? You supply the learned advocate
Yes,
so that he can.
In another suit, we have amended our address and served them the amended copy.
Then you do one thing. I'm adjourning the matter. You take necessary steps. You ask from him the necessary address and you take necessary steps. Okay.
My lord, I'm not. My lord, on the last occasion, my learned friend submitted that there is no vokalatna. But I am appearing since last 5 years in this matter, and they are serving me the copy also. But all on a sudden, it seems that the no vokalatna has been filed, and I am saying leave to file vokalatna.
Yes.
Kindly do not grant that. In that event, it would be an undefended suit. If they have not entered appearance through any advocate.
My lord, written statement has been filed.
Written statement is filed, but no vokalatna.
হয়েছে ভোকালতনামা হয়েছে ভোকালতনামা ফাইল আছে বাট চেঞ্জ ভোকালতনামা has not
change
ভোকালতনামা
Yes, record and order.
has been filed.
Learned advocate for the plaintiff and learned advocate for the defendant number 1 are present. The matter on the prayer of learned advocate for the plaintiff, the matter stands adjourned till 3/7/2025 to enable the plaintiffs to take necessary steps. The learned advocate for the defendant number 1 is permitted to file the vokalatnama.
But only one indulgence, my lord.
Yes.
If your lordship also directs the learned advocate for the defendant number 1 to provide us the address of the defendants. So once
Yes, learned advocate for defendant number 1 is requested to furnish the present address of the defendants.
Grateful.
Item number 28.
Suit, Your Lordship. It has to be converted into a commercial suit, Your Lordship. It's a contract for the supply of the explosives to the Coal India, Your Lordship. It's an old matter. It should be converted, Your Lordship. Initially, in another explosive matter, Your Lordship, this was the order passed by the Honorable, another coordinate bench, Your Lordship.
28 and 29.
28 and 29, Premier Explosives and the Rajasthan Explosives. Similar order may be passed, Your Lordship, so that it can be converted and the steps can be taken in the meantime, Your Lordship. I want some more time, Your Lordship. Here the 1 month is given, 2 months because it's there in, one is in Hyderabad and one is in Secunderabad, something like that, Your Lordship.
So the matter has to be released from this bench and
has to be, it will go there, Your Lordship.
Yes,
but Lordship has to convert it, then only it can be listed there. Lordship will see the order. The suit is transferred to the commercial division. Since the dispute involved commercial in nature, department is directed to take necessary steps in this regard. So conversion has to be there. Until unless it is converted, it will not be listed there.
Yes, record an order. You are for the plaintiff.
I am for the plaintiff.
Learned advocate for the plaintiff is present. It is submitted by the learned advocate for the plaintiff that the disputes involved is commercial in nature. Thus, the matter is to be taken up by the commercial division. Stop. The suit stands released from this court. And be placed.
Lordship, do not have to release because once it is converted, it will automatically go.
The suit stands released from this court and be placed before the department to take necessary.
No, Lordship has to, suit is transferred to the commercial, transfer has to be made.
The suit is released and be transferred to the commercial division.
Lordship, since the dispute is
commercial division, let necessary steps be taken for the conversion and let the matter appear before the appropriate bench.
Lordship. I will mention it, I will get it mentioned.
Yes.
Lordship. Deeply obliged. The department may be directed to take necessary steps.
Yes, department to take necessary steps
in the matter.
Item number 30.
Lordship, on the last occasion, Lordship has given us some time to disclose documents.
Yes.
We have obtained some of the documents. My Lord, your Lordship will kindly give me 3 weeks more time so that all the documents can be gathered. My Lord, the defendant is not appearing.
Okay, serve notice upon the other side.
My Lord, we have already served. There is nobody in the address. So, my Lord.
A written statement filed.
No, my Lord. Nothing.
So it will appear as under the heading undefended suit.
Yes.
Okay, record an order. Learned advocate for the plaintiff is present and prays for time for 3 weeks time for further inspection.
For further disclosure.
Further disclosure of the documents. The prayer is allowed. Let this matter appear on 9/7/2025, 9th of July.
Item number 31.
Lordship, I appear on behalf of the plaintiff. Your Lordship will recall this is the matter where Your Lordship had given directions upon the official liquidator to be present physically.
Yes, probably he was present.
Yes, and
yesterday or something he was present. And he intimated that
it was given late, Your Lordship. It was communicated on the last occasion.
So let it be not today. You intimate him. It will appear tomorrow because he apprised me that
Yes, I kindly give him some time. I think a week's time will be required because it is at our fault, Your Lordship. The I have the letter here right here. I don't have a affidavit of service ready, Your Lordship. Give me 2 days time. I'll
Okay,
file the
just
affidavit of service. In the
learned advocate for the plaintiff is present and 6 time to communicate.
No, we have communicated to file the affidavit of service.
To file the affidavit of service.
So that Mr. Ranajit Chaudhary can take instructions and come back after a point of time. Your Lordship extends the time.
Let this matter appear on when 1st July 1/7/2025. Learned advocate for the plaintiff is requested to intimate Mr. Ranajit Chaudhary, learned advocate, about the next date fixed.
And to take instructions with regards to the order.
And to take necessary instructions.
In relation to the order passed on 21st May 2025.
You communicate both the letters.
Yes, Your Lordship. So that
let this order along with order dated
21st May 2025.
21st May 2025 be communicated to Mr. Ranajit Chaudhary.
Grateful. 1st of July, Your Lordship is keeping it. Grateful.
Item number 32.
Yes, not today.
33.
Not today.
34.
34, I am for the plaintiff, my lord. My lord, we will issue notice, my lord, to the defendant intimating about the matter, my lord. We have taken the records, my lord. There is some discrepancy in the records. We are unable to trace everything. So, my lord, we will issue notice, my lord, to the defendants. And, my lord, on the returnable date, the matter may be taken up.
So, issues are framed in this case?
My lord, actually, my lord, we are not aware because this suit is coming after a very long time, my lord. I was not there initially. Now I have been briefed.
Is it change brief?
No, it's not a change brief. My lord, the junior who was looking earlier is not there anymore.
Yes, learned advocate for the plaintiff is present and praised for time to take necessary inspection. Let this matter appear on 2/7/2025.
Yes, my lord. Not same with item 35.
35 also same order.
Extremely grateful.
For arguments, item number 36.
May it please, my lord. Our application, my lord, for revocation of grant of probate.
That is GA1.
Yes. And
My lord, I'm appearing for the respondent, my lord. There has been
an executor.
Yes, my lord. My lord, there has been a change in the matter, my lord. However, although we have attempted to file this vakalatnama in the department, I am being told that the erstwhile advocate did not file a vakalatnama or the name, or it's not in the records. That is why they could not take our vakalatnama, my lord. It's been executed way back in May. So if my lord may kindly issue an order to that
This is a change brief.
It's a change brief, my lord. We are appearing for the first time today, my lord.
Correspondent executor.
Correspondent executor, my lord. I'm being led by Mr. Ratnanko Banerjee, my lord. If my lord could kindly adjourn it for the day and keep it for any other day, and meanwhile pass a direction to accept our vakalatnama.
Yes, when shall I keep it? Some other day.
Any day is convenient to my friend.
Any day other than tomorrow.
Except for the 1st, the 30th and 1st, I'm not.
Yes, Mr. Banerjee has come.
He doesn't have any power. Advocate record doesn't have a
No, correct.
I don't think it's.
The affidavits are complete.
Yes, ma'am.
Yes. Lord, there's a change, my lord, which my advocates have taken recently. My lord, the vakalatnama, they've got it also with sign and no objection, but I'm thinking
Anyway, I'm granting opportunity to file that.
Yes, very good.
And keep it on some other day.
Yes, my lord.
Yes, record an order.
After the 1st one.
Learned Mr. Ghosh, learned advocate for the applicant, and Mr. Banerjee, learned advocate for the respondent executor are present. Learned advocate for the respondent executor. 6, leave to file the vakalatnama. They say such leave is granted. The vakalatnama may be filed.
7th, 8th.
Let this matter appear after 1st July.
Yes.
Lord, 7th, 8th, my lord, if it's convenient to my lord.
Yes.
আচ্ছা 8 তারিখে 3টের সময় কিছু নেই তো? 8 তারিখ, 7 বা 8 তারিখে, 7 তারিখে দেখুন 3টের সময়।
No, department, I think.
What is the lady's name?
8 তারিখে
8 তারিখ তো বলছি কেন?
মানে 2টোর সময় নেই, 3টের সময় নেই, হ্যাঁ? না আজও
7th
কিছু ফিক্স হয়নি। Okay, I'm keeping it on 8th.
8th, my learned friend won't be 7th, if it can be 7th or
আচ্ছা 9
9th.
তারিখে দেখুন।
9 তারিখ আমরা 2টোর সময় না।
9th.
9th এ রাখিস না তাহলে।
10th.
10th. Sorry, my lord. Very sorry, my lord.
10th, all of you are.
Yes, my lord. Yes.
10th at, this is Thursday probably, 10th.
Yes.
3 p.m.
Very yes. Grateful.
Chamber application. It's coming as a chamber.
Department of
How does it matter?
Complete list.
3 p.m. fixed.
And my lord, we can, on the basis of my lord, the server copy, my lord, we can file the wakalatnama because otherwise,
Yes.
because certified copy, my lord, will take out again, my lord.
No, so it will be accepted definitely as a server copy.
I'm grateful.
হ্যাঁ, না সেরকম করলে অ্যাডমিনিস্ট্রেটিভ নোটিশ পাঠাতে হবে আর কি। আচ্ছা তাহলে কালকে তাহলে ইয়ে করবো, কালকে দিয়ে লাস্ট চান্স করে দেবো। কাল যদি না আসে তাহলে লাস্ট চান্স করে তারপর অ্যাডমিনিস্ট্রেটিভ নোটিশ, তারপর ডিসপোজ। আচ্ছা যেটা ওই চেম্বারে যেটা ফরওয়ার্ডার্স বললাম হয়েছে, হ্যাঁ ওই কেসটা একটু কস্ট টাইটেলটা আমাকে একটু দেবেন তো, এখন ফরওয়ার্ডার্স কটা হয়েছে আর কি। হলুদ ছয়তে চলে গেছে? না ওটা চেম্বারে হয়েছিল। 16/6 তো চেম্বার ডে ছিল না? 16/6 তো সোমবার ছিল। 17/6 ফরওয়ার্ডার্স কবে হয়েছে? মানে মনে আছে চেম্বারে বসে ওটাকে
সবে পড়েছিল আজকে রুদ্র কি answer is this a hippie thing or a thing? It's most embarrassing. Where is this from?
বিশ্বজিতের ফরওয়ার্ডার্স আছে? অর্ডার মানে ফরওয়ার্ডার্সে ডেট পড়বে আর কি।
কালকে 2টোর সময় হবে তো পয়েন্ট কবে আসবে? পয়েন্ট আর জয়েন 5
চেম্বার তো
that'll be in that word.
চেম্বারে ছিল কি?
এও আছে সুগত ওয়ালনাস ডি
কবে আছে? 19/6 মানে এই কালকে এটা পাঠাবেন তো, এটা আমার কাছে নেই, চেম্বারে তো নেই বোধহয়। আচ্ছা
ইয়ের কাছে মনে হয় নিচে দিকে।
ঠিক আছে, একটু তাহলে একটু দেখে দেবে, স্লিপ একটা পাঠাবেন।